bench found that this matter supposed to be listed division bench custodial that matter. I have marked it. Item number 5.
I put in Lordship custodial that it should be go to the division bench number 2, Lordship.
Okay. It appears that this matter has been wrongly listed as it pertains to the division bench. Raise free to verify and list before the appropriate bench.
Obliged.
Is the number the same? There may be two other.
Sorry,
4329. No, name, don't go by the name. There may be two cases.
4329, Lord.
Yes.
4329.
Correct.
4329. Oh, yeah, third salary. Sorry.
I'll solve file. No? দুটা ডিভিশন বেঞ্চ থেকে আছে তাহলে কি অফিস নোট তো কি দেয় বলে কেন কে है হ্যাঁ বেটা না
As far as new notification, it should be good. Earlier,
it was already in the division bench on 2/6/2023. Why has it been listed here? We do not know.
yes,
Well, there's a review matter, item number 16, my lord. This will time be at 2, my lord, maybe, my lord.
We cannot say this. Top of the list is 13 matters.
13 matters.
13. That and there is a part heard. First, we take the 13 matters top of the list, then the part heard. But we'll try.
You know the review.
I know, sir. It was reviewed by the division bench.
One thing before your lordship start of the case, my lord, kindly see the prayer in the writ petition. And I'll just show.
How many repetitions are there?
There are
4 numbers, my lord.
4 numbers. Kindly see the prayer.
Yes.
Page 32 is the prayer.
Yes.
32A is the prayer.
Yes.
In the premises aforesaid, it is therefore prayed that your lordship may be pleased to admit this petition, call for record, issue a rule calling out respondent to so cause as to appropriate writ or any order should not be issued, direct the respondent to immediately cancel appointment of the respondent 6 to respondent number 21 and issue a fresh advertisement mentioning the proper qualification are directed by this honorable court in judgment dated 26/2013 passed in WPC for appointment to the 16 number of posts as equivalent and to initiate a fresh selection appointment process for the above posts and so. Your lordship may rule so and so. Private. This is the prayer which they have made because they said that there is an order which has been passed by this honorable court so far as the qualification of the inspector of school is concerned. So you need a B.Ed for that post. That's
What about what is the interim prayer?
for interim prayer is a final disposal to so directing the state to not to confirm the service of private. Already we have been appointed.
And to register a CID case.
Because
that is not the relief you are claiming. How can you claim it in an interim relief?
that's a main not relief.
My lord.
You have not paid for any relief for an inquiry by the CID.
My lord, we have an FIR had already been registered.
No, how can you make a prayer in the interim?
Where is the man? My lord,
No, that has not been granted at that stage.
Okay.
Can I
So
just
we are
say
not-
one thing? My
Yes.
lord? The prayer which they have made as on date has become infructuous.
No.
Because I am telling you why. I was engaged by a learned friend before this court. and apprise of some few of the respondent appear. But when he engaged me in this matter, and when I have seen that there is a great impediment for us because there is an order passed by division bench. So in this the main which they have now pointed, then I went. My lord will kindly see. I'll show page 86 also. Then my lord, we have seen that the division bench which order have been passed on the basis which has been annexed on the basis of an affidavit that has been filed by the government, and that with great respect, division bench I showed to the division bench as somewhere some mistake was done by human being ultimately. So what they have said, they in pursuance to the affidavit that has been filed by the commissioner secretary for the post of inspector of school, B.Ed is required. Then I thought that the affidavit is something else. Affidavit says not the inspector of school, assistant inspector of school. I file a review application. After a long time, I came up before division bench. Review was filed. Then the court, my lord, realized that what was the affidavit that was filed and what was the order that was passed by division. They reviewed the order, my lord. They reviewed the order to the extent that for the post of inspector of school, B.Ed is not required. So that precisely that is a prayer. That is a prayer they made. So how can we be appointed without having that B.Ed? That has been, my lord, I will show before your lordship. What is a prayer that is made, whether as on today, the prayer which they have made, whether it is existing, is subsisting. That I was just want to point out before your lordship. Kindly see the review order. Kindly see page 86. That's why it will be futile exercise, my lord. Page 86, kindly see, my lord.
Yes.
86, my lord, will kindly see. This was the order passed by this court. 26, 2013. Lordship got it? Challenge the writ petition, propose appointment to the post of inspector of school out of candidates who do not possess BT, B.Ed degree, which qualification required for lower post. Matter was earlier time was given. Accordingly, affidavit dated 6/6/2013 has been filed, which in substance accept the stand of the petitioner. In view of the stand taken in the affidavit dated 6/6/2013.
That was a stand with regard to deputy inspector.
No, that's what my lord.
But it was taken to be the stand in the inspector.
Absolutely correct.
Where is the review order?
Yes, review is kindly see.
I think the affidavit page 74 is the operative part.
Yes.
Paragraph paragraph 6,
Yes, yes.
the last line.
Last.
Therefore, BT, B.Ed degree is also essential for the post of deputy inspector of school.
Yes.
There is no reference to inspector of
No,
school.
that's why my lord, your order was modified.
Where is the
Kindly
modification?
review see kindly. Para 16 kindly see.
Page.
This is page inner page 17. That's a below. 17 below is there. This review I have this order review. My
Okay.
we have given. Kindly say 17. 17 below.
Para 17.
16. Para 16. We therefore modify and clarify the order dated 26/2013 to the extent that a prescription or a rule
Yes.
as on the requirement of BT for the lower post of the, but the same is not an essay qualification for the higher post of inspector of school.
You are not connected to assistant inspector of school.
So this
You are connected only
all
with inspector.
inspectors of school. They are the candidates.
Is there anything to be adjudicated?
Yes.
My lord, if my lord may be pleased to allow the hearing, my lord.
No, obviously we are here to hear you.
My lord, not only the issue of the B.Ed, my lord, all these persons, my lord, has obtained the appointment by submitting false and fake documents. That is also another contention in our writ petition, my lord. And those fake certificate is also a part of the record, my lord. That is another contention. And the issue of the B.Ed, my lord, what has happened, my lord, in the year 2012, my lord, we move a petition before this honorable court with a contention that a particular part of the rule had been challenged, my lord, saying that once the government has made the rule that the B.Ed is a requirement for the deputy inspector of schools, so therefore for the higher post in the cadre, that is the inspector of schools, the B.Ed degree was not made compulsory. So therefore the state provision was not rational. Now, my lord, when the government has filed an affidavit, my lord, that affidavit is also on record. Then, my lord, this honorable court has clarified that the government will take up the issue and do the needful for the purpose of insertion of the B.Ed degree for the purpose of inspector of schools. So as a result, my lord, what has happened in the meantime? These persons, my lord, the present respondent, which has been represented by respected senior friend, my lord, had already been appointed. So therefore, my lord, this when the appointment has been made, we put into challenge this by way of this writ petition, basing on the relying on the clarification as well as the judgment passed by the division bench that the B.Ed is a mandatory degree, and in the advertisement, my lord, which has been made, and this B.Ed has not been given the preference or the mandatory degree in the advertisement. That was also a contention in our, my lord, this writ petition. Now, my lord, of late, recently, my lord, I have also recently come to know that a review petition, my lord, has been preferred before the honorable court for the review of the very order passed by the division bench,
Correct.
my lord. And the honorable division bench was pleased to clarify that it will run as a, my lord, I have not done so as a whole of the review order, my lord, but what I have learned that, my lord, it will run prospectively and it cannot have a retrospective effect because on the day when the advertisement was floated, my lord, in the rule, there was no requirement of the B.Ed, my lord. So that's, my lord, that as for the clarification, my lord, I have to also submit clearly before my lordship that the ground which we have taken that the B.Ed was not made in the advertisement, my lord, that may not have a matter of adjudication furthermore. But the other issues, my lord, which we have pleaded in our writ petition, that why this person is underqualified, how they have taken the recourse of forgery and fabricated document has been presented, my lord, along with their application. By those, my lord, it was a mandatory requirement in the advertisement that work experience certificate is required. All those work experience certificate, my lord, is a false and fabricated, which we have obtained through RTI. The issuing authority say, I have not issued any such document. These are the, my lord, is not within my knowledge, my lord. Those things, my lord, is required to be adjudicated.
These statements of facts are admitted or disputed?
No, my lord, this has been, my lord, they have disputed, but the other, obviously, my lord, they are not going to admit those things, my lord. But
No,
the
Mr.
issues,
Bhuya,
my lord,
we cannot say anything on merit.
my lord,
We cannot come to a finding that your allegations are false or incorrect
my
or
lord,
their defense is correct.
my lord.
But are we in a position to adjudicate an issue where involves disputed questions of fact
My lord,
that of serious nature?
my lord, these are, my lord, with my very poor and limited understanding, my lord, these are not disputed. Why I am submitting, my lord, because the issuing authority on record, my lord, they have said that I have not issued, my lord. That's
Mr.
the matter,
Bhuya,
my lord.
we can just add
My lord,
that this statement of yours
my lord,
needs to be proved in accordance with law.
my lord.
These are serious allegations.
Serious allegation.
The person who is issuing, he said, I have not issued.
My lord.
Has he been cross-examined?
No, that cross
Do we have that
examination.
do we have that
Examination
do we
is
have
not
that expertise or mechanism in a writ court to cross-examine?
my lord.
You know better. They are anybody making any statement, the other side is entitled to cross-examine him.
My
That
lord.
is the fundamental
My lord.
to expect the truth.
My lord.
Now you are depending on a document which they are disputing.
No, they-
You can file a civil suit,
no, my lord,
challenge their
my lord,
appointments.
for the purpose of forgery, my lord, we have already filed my lord, my lord, may be pleased to find my FIR, my lord, is at page 131.
What is the stand of the department?
My lord, department is, my lord, the very silent regarding all
If
these
the
issues.
department would have supported you,
Yes,
matter would have been a slightly different.
department has not, my lord, department
If
is
the
not
department is
aware.
also not supported you,
Or my lord may call for the status of the CIDPS, my lord. It will clarify everything, my lord.
CID case is not the purview of our examination.
No, no, my lord. See, because, my lord, with all respect, my lord, what I respectfully beg to submit, my lord, is as this appointment is the, my lord, basing on some mandatory qualification or the criteria. My
See,
lord,
this
my
case is
lord.
not filed, it has not been filed for monitoring a CID case. Otherwise also our role is very limited in a criminal case. We are not monitoring. Unless it's a case of heinous, some offense which stalks our mind, then these are counter allegations.
My lord, they have obtained the public service, my lord.
No, we are not
My
saying
lord.
for a moment that you don't have a case at all. You may have a case,
My lord.
but this is the proper forum for adjudication.
Yes, my lord, with my limited understanding, my lord, as we have approached the criminal investigation department with a specific allegation, my lord, that they have used this false document.
You pursue that.
No, my lord, that person, my lord, as we already, this is a part of the record before my lordship, and nothing has
Which
been
case? In which case?
my lord, at page 131, my lord.
Which case?
My lord,
Where is the relief you are seeking? In connection with a criminal case.
my lord.
That's a separate mechanism altogether. You are entitled in law to pursue. But these allegations, we are again reiterating that you may be correct. But being correct will not be enough. You have to prove it in accordance with law, establish it by giving them a fair opportunity. And if the authorities would have also supported you, matter would have been different. At least prima facie we come to a finding that forgery is there. What are you doing in the criminal case? That we could have said. But when the department is silent, they obviously will say no. Nobody is going to admit to a forgery.
My lord, their intention was also common, my lord. That they have also supported.
Under those
this court document.
circumstances, and since the principal basis on which this petition has been structured,
My lord.
namely the order of the division bench,
Yes,
that has been reviewed.
my lord.
The requirement of B.Ed, which the division bench had one time thought that it would be applicable to IS, was actually in the affidavit for the deputy inspector of school.
My lord.
That has been clarified.
My lord.
So that part you perhaps will not have a case. Your case will only revolve around the allegations of forgery.
My lord.
On those allegations, how far can you go in a writ petition?
My lord,
We'll come to it. 4. Same allegations. Same allegations. One affidavit has been filed.
My lord,
One thing. There was an earlier round of litigation. There was an
Oh,
earlier.
we'll come. Just,
my lord, if my lord may be pleased to take up my lord one rejoinder affidavit, my lord, I have filed it.
no, Mr. Bhuya, we may go in details.
No, my
But
lord,
first you make up your mind
yes, my
that
lord.
whether we hear it for 1 day, 2 days, 2, 3 days,
My lord.
whether we come to a conclusion that the allegations which are made are admitted or undisputed.
My lord, and for that, my lord,
Is it possible?
my lord, for satisfaction of my lordship, my lord, if my lord may be pleased to take up my rejoinder affidavit, my lord, wherein I have
In the
submitted-
first writ petition?
Yes, my lord, in WPC 5752 of 2013, my lord, and I have filed it on. My lord, I have filed it
Page.
on. My lord, this page in nation, my lord, at that.
You tell your page. 572.
No, my lord, it is not chronologically.
5752.
Yes, my lord, 5752.
We'll find it out. Don't worry.
My lord, it is filed on February 2016. No?
By whom?
My lord, by Rajesh Chakraborty, my lord. I have made a table, my lord, in paragraph 6, that how and in what
Let
manner,
us.
my lord.
Jaipal Singh Brahma.
No, sorry to reason. Copy 9.
अभी को आने
Copy दिया ना? ठीक है, sir.
These are all dependent on position.
common key है rejoinder.
Rajesh Chakraborty,
My lord,
common rejoinder.
my lord.
Yes.
My lord, a common rejoinder, and if my lord may be turned to page 4, paragraph 6, my lord.
Just a minute.
दिया नहीं, copy दिया नहीं.
It is given to Sri SSJ, Standing Council Education, Standing Council APS.
My lord.
I think we were not served. Like we have not been served this copy.
It's a common affidavit
My lord.
for 8, 10, 12, 13, 14, 15, 16, 18, 19, 20, and 21. Chaudhary is appearing for whom?
I appear for 3 respondents.
In this writ petition.
The respondent number 9. 1 and 12.
In 5752.
1 and 3, item number 9.
Is it WPC 5752?
My lord.
No. That,
In 5752, I appear for 10, 12, and 16.
okay, 3 respondents. And you are also in 5752?
5, item,
5752, I appear for 9.
I appeared for 19 in 5752. Right?
And that is item number 1 and
Item number 1 and 3.
No, that is okay. We want to, because
Yeah.
this rejoinder has been filed only in 5752. if you are parties in 5752, perhaps you will be entitled to a copy.
We are not subject.
The common has been filed,
That is
so it is applicable.
applicable.
So I have to write
Yes, yes.
to look into it, my lord, and see what is the contents they have made.
Okay, keep it. Tuesday. Day after tomorrow. We can have it day after tomorrow. Serve a copy.
My lord,
Anything else like this?
No, my lord, one thing is that what I found subsequently, that writ petition itself, maybe because they have prayer, I want to bring notice to the court. Secondly, as your lordship viewed, I also, my point will be disputed question of fact. And what they have done, whatever the allegation of forgery, they did not make the party also. Headmaster is not made a party. Somebody said you don't issue this certificate, withdraw the certificate. They did not make
No,
a
no.
party.
In fact,
These are all disputed.
in fact, what we are proposing,
Yeah.
let the pleadings be the copies, whatever is not been exchanged. Let it clear. You should have a chance. And first, we propose that we'll see whether these are matters which can be looked into by a writ court. On prima facie, we'll see. Because if we are satisfied, then we'll go into the other allegation, whether it can be. Otherwise, we may have a different view. We'll also hear Mr. Saikia, whoever is there. Mr. Islam, you are also there. Yes. We'll
So
hear
let
you.
it- My lord, let it keep as a partner. And after
No, these are all matters. They'll come day after tomorrow. But serve the copy.
My lord,
Any
today-
more copies have to be exchanged. We don't want the matter to be adjourned on day after tomorrow.
I have already served copies, my lord, to my respected senior friends, my lord. That may be treated.
And Mr. I. Chaudhary is also there.
Yes, yes, my lord. I have given. Dada,
None,
person?
none.
I have copy detail, Dada.
Who is with you, Mr. Chaudhary? Borua, take a copy. Anyone else? Chauhan, you are appearing. Copy served or not? 17, you have not filed affidavit. You have not filed affidavit.
Not filed, my lord.
5906, who's appearing? 5906.
5906, we are appearing.
No, you are respondent. Who's for the
Respondent
petitioner?
19.
No, who's for the petitioner?
Yes.
Mr. Bhuya, you are also there.
Fine.
5950. Have you filed rejoinder in Chauhan's case?
My lord, that has been, my lord, the brief has been taken back.
Nobody is appearing for 5950.
This moment, I don't think so.
Huh?
In 5906, I'm there.
But petitioner is not there.
No, it's not there. Very good.
So you may not need, no need to educate
My
5950.
lord. Lord, actually, it is the issues are same, my lord, 5752, but no representation.
Okay.
My lord, may I humbly pray, my lord, that
Any more exchange, Talukdar?
Lordship, in 5906, Lordship, my senior counsel was appearing, DK Sharma. Probably he's in the Lordship government advocate, so he could not.
But you are you appearing?
Lordship, my name is not recorded.
Doesn't matter. If you can appear on instructions.
Lordship,
You're for the petitioner.
Lordship, petitioner in
5950.
5906.
Your case. Have you filed affidavit of rejoinder affidavit to Mr. Chauhan? We know you have filed counter. Have you filed rejoinder?
No, Lordship.
Have you received the counter affidavit?
Lordship. Lordship, I have received the application in opposition, Lordship.
Yes, counter affidavit by respond number 17. Is it 17?
Phone number.
Deponent is Jagadish Prasad Burman.
Reply we have not filed, Lordship.
Not required. But have you received the copy of the counter?
Lordship,
Okay.
we received that.
Any matter where we are not joining for filing of any new pleadings, only for exchange. If copies are yet to be. So then we have it day after tomorrow.
Lord, my lord, may I humbly pray, my lord, can be taken up on next Tuesday, my lord.
The next case will be difficult. And these are matters top of the list. You know what is the purpose.
I know,
These are very old matters, day after tomorrow.
but the request for some question has been come up, my lord. We will take that.
You should be prepared for this question. The writ court.
My lord,
First, you have to overcome.
my lord. We'll try to satisfy, my lord.
It appears that though a common rejoinder was filed,
Okay, no.
rejoinder affidavit was filed by the petitioner. By the petitioners against the affidavit in opposition of the private respondents, copies thereof were not served upon the learned counsel appearing for such private respondents. However, the such copies have been served in the today itself in the court. In the interest of justice, matter is adjourned to be listed again on Wednesday next, as Wednesday next on top of the list.
On Wednesday.
Oh, sorry, not Wednesday.
No, see, that's why I
Thursday,
was
sorry.
just.
Not Wednesday, Thursday.
This
Day after
Thursday,
tomorrow.
This Thursday.
Yes.
That's why I was.
Day after tomorrow.
Obliged.
Deeply obliged. The review is I have given to
Yes, yes, you can.
Your lordship can keep this.
You place this on the other
I'll place it on the other.
part.
I will say, I will probably go.
No, I don't know. Part. Further consideration tomorrow. Further consideration will be within up. Where is your friend? Varman. But we have heard him actually. You can give the dates, relevant dates. Yes, just the factual background. আমি খালি নোট গুলো কোট করেছিল না করা এখন তাদের কাগজ ডেভেলপ নোট ডেভেলপ খালি নোট easy note লম্বা টাইপের আছে এটা লম্বা টাইপের আছে না? এটা একটু না, একটু না, মনে Yes, what was it?
Lordship, petitioner's parish lordship in parish 26 lordship. Here lordship, petitioner prayed for lordship for promotion to the post of senior instructor to lordship as a lecturer lordship.
From senior
Senior
instructor.
instructor to lecturer of polytechnic college, polytechnic institute lordship. Here he has challenged the lordship the DPC's minutes dated lordship 27/1/2016 lordship.
14
27/1/2016 lordship.
page.
Page lordship 74 lordship. It start from page 74 lordship.
Yes.
74 to lordship 78.
Seventy-four.
74 lordship.
27/1/16.
Lordship 27/1/2016
Yes.
lordship. Whoever lordship some persons are some incumbents are promoted to the post of principal lordship. And HOD also lordship. And lecturer HOD also lordship and lecturers also lordship. Where their case is not considered lordship, so they have.
Where is the consideration for lecturers?
Lecturers consideration is lordship.
Page
76 lordship. The
76.
committee has also recommended the following incumbents for promotion to the post of lecturers in unreserved category in existing vacancy from senior instructor and foreman on the basis of the seniority and requisite qualification.
Yes.
They have challenged this part.
Yes.
Because they are not under the considered term lordship. The main contention of the petitioner is that lordship he has fulfilled the required qualification prescribed by the lordship 1981 rules lordship. And he also says that lordship the 2004 OM is not applicable in the petitioner's case because that particular OM is in respect of the direct recruitment. And one of the contention of the petitioner before lordship is that lordship there is no any lordship nomenclature in respect of the post of foreman senior instructor in the AICT's notification. And he says that AICT's notification is applicable from the stage of lecturers only. And he also paid that one of the honorable court judgment is there in 2016 lordship, whereby
The AICTE.
The content of the petitioner is that AICT's notification is applicable from the stage of lecturers. And AICT notifications nowhere provide lordship regarding the qualification which is required for promotion. is the contention of the petitioner. And petitioner says that, Lordship, that the qualification prescribed by the ICT is not applicable in the petitioner's case, and the OM is also not applicable in the petitioner's case.
And there is a judgment.
There is a judgment of the Honorable Apex Court, our High Court in the Pradip Tamuli's case, Lordship. It is also annexed in this petition, Lordship. It starts from, Lordship, page 167, Lordship. Page 167 to 172, Lordship.
Judgment.
Judgment of the our High Court, Lordship. It's in WBC, Lordship. PT27 2011, Lordship. Order dated is 01/08/2016, Lordship.
Yes.
And petitioner relying mainly paragraph 17 and 18, Lordship. 17, 18, and 19, Lordship.
Okay.
On the basis of that paragraph, Lordship, petitioner says that he is eligible for promotion to the post of lecturer, Lordship, from the senior instructor, Lordship. The extent of the department is, Lordship, we have filed our affidavit in paragraph 14, we have stated, Lordship.
Affidavit filed on?
Affidavit filed on, Lordship, 9/12/2020, Lordship.
Just a minute. Atul Bora,
Lordship, Atul Bora,
2020. Yes.
2020, Lordship. Here, Lordship, in paragraph number 13, we have stated regarding, Lordship, the DPC, Lordship, when DPC was constituted.
1-3.
1-3, paragraph 13, Lordship.
Yes.
And paragraph 14, we have stated regarding, Lordship, the required qualification as per rule 11T, and also that particular amendment was done, Lordship, as per the ICT's notification. And when the amendment was done, it was also mentioned that, Lordship, regarding the OM of 2004, Lordship. So, Lordship, we have quoted the OM part also, Lordship, and as well as, Lordship, ICT's notification part also, where we have stated that, Lordship, required qualification is, Lordship, in Roman 4, Lordship. In Roman 3, Lordship, we have stated regarding, Lordship, the ICT's qualification, internal page 5, Lordship.
Yes.
Roman 3, Lordship, we have stated that the Assam Technical Education Service Rule 1981 has been amended by Government of Assam notification dated 1st July 2008, and the same is called as the Assam Technical Education Service Amendment Rule 2018. According to clause 5 of Amendment Rule of 12, Lordship, subject to suitability, an officer shall be eligible for promotion if he possesses the qualification experience as prescribed by the ICT from time to time as adopted by the State of Assam. It is, Lordship, also incorporated in Rule 11C, Lordship. Rule 11C, and the qualification part is there, Lordship, in Roman 4, Lordship. Bachelor's degree in engineering and technology in the relevant branch with first class or equivalent. If the candidate has master's degree in engineering and technology, first class or equivalent is required in bachelor's or master's degree level. Admittedly, Lordship, petitioner is a, Lordship, second class in computer science, so he has not fulfilled the required qualification prescribed by the IIT. Here also we have stated he possesses second class in a requisite bachelor's degree in computer science and engineering, which does not fulfill the IIC's norm of requirement of first class, Lordship, for appropriate branch law. And, Lordship, in 11, section 11(3), Lordship, section 11 also says that, Lordship, he should be, Lordship, for 8 years in continuous service, Lordship. 11(3).
You are referring to?
Assam Technical Education
Page,
Service
page.
Lordship, 747, Lord.
The rule.
Rule 11, Lordship.
Rule starts at page.
Page 747, Lord.
No, rule Starts at 741.
Rule starts for Lordship.
741.
Lordship. And Rule 11 deals with the promotion as a lecturers of polytechnic. And 11.1 says that Lordship, the
At
manner which the
747.
Lord 747.
Rule 11.
Rule 11. Rule 11 in respect of promotion as a lecturers of polytechnic Lordship. And 11.1 says that the manner and procedure prescribed in Rule 13 and 14 will be applicable Lordship. Eleven one Lordship.
Yes. We
It says
discussed
that the procedure should be applicable
Yes,
as
we
per
had noticed this yesterday.
Lordship. And Lordship 3, 11.3 Lordship. 11.3a Lordship. He was rendered service in the respective cadre for a minimum period of 8 years on the 1st of January in the year of promotion Lord.
Hmm.
And he has successfully undergone the training and passed the departmental examination as may be prescribed for the purpose Lordship. And C Lordship, it substitute as per amendment Lordship 2008. He possesses the qualification and experience as prescribed from the cadre of lecturers polytechnic as prescribed by the AICT from time to time as adopted by the government of Assam.
Yes.
Admittedly, Lordship, the qualification part Lordship petitioner only second class Lordship. And regarding the experience part also Lordship, in computer science department he has served only from Lordship 1/8/2017 Lordship. On limited period 28/6/2017 to 1/8/2017 Lordship. It is in
Now, when did he serve as computer science?
computer science Lordship in internal page 6 or affidavit Lordship in B Lordship. Originally he was a data entry operator.
Hmm.
If Lordship permit, I can read it Lordship.
Please.
The petitioner having BTech degree in computer science and engineering yet has not completed 8 years of regular service in the capacity of senior instructor in computer science and engineering, which is mandatory for his promotion to the post of lecturers in computer science and engineering as per Rule 11(3)A of the Assam Technical Education Service Rules 1981. Petitioner is initially appointed as data entry operator and then was adjusted and placed against the vacant post of senior instructor in other subjects like electronics. He was again adjusted and placed in a non-teaching post of lower division assistant, now junior assistant, for a long period from 17/8/2006 to till 28/6/2017. In that particular period, he was a Lordship junior assistant Lordship. Later, the petitioner was transferred from Silchar Polytechnic and placed against the vacant post of senior instructor in the Department of Computer Engineering in Nalbari Polytechnic for some days with effect from 28/6/2017 to till 1/8/2017. As his service has been again readjusted and placed against the vacant post of senior instructor in other subjects like printing technology with effect from 1/8/2017 in the same institute, Nalbari Polytechnic. So Lordship, he has not fulfilled the required experience part also. 8 years period.
He served only for about two months.
Lordship. Basically, his long service period, Lordship, he is rendered as a junior assistant Lordship. From Lordship 17/8/2006 to 28/6/2017. So Lordship, he has not fulfilled the required qualification which is prescribed by the AICT and as per the 1981 rules Lordship. And regarding the judgment Lordship,
Yes.
Regarding the judgment, yesterday Lordship has already granted Lordship in 168, page number 168. It
Yes.
starts from Lordship 168, Lordship, paragraph 5. Paragraph 5, Lordship, the DPC was held on 27/1/2016, Lordship, prior to the amendment of the 2008 Act. Lordship. And review was also done in 20/01/2007, Lordship, in respect of that particular DPC law, before the amendment of 1981 rules. Lordship. On the basis of that, Honorable Court's finding is that, Lordship, as because there is no any amendment, and OM is, Lordship, in respect of the only for direct recruitment, and the criteria which is prescribed in the OM is, Lordship, promotion to the senior lecturer. So Honorable Court finding is that, Lordship, that particular OM is not applicable, Lordship, at the relevant point of time. Lordship. And here the petitioner's case was considered in the DPC in 2016, Lordship, after the amendment of 2008 Act, Lordship, whereby HC was substitute, Lordship. It is as per the AICT's required qualification. Lordship. So, Lordship, our Honorable High Court judgment that is not applicable in this case, Lordship. It is prior to the amendment, Lordship. The consideration was took place 2016, Lordship. Okay.
Who is your friend?
And Lordship, even my Lord have also yesterday told him that as a first item matter will be taken.
But we have heard it. Record is present.
And he was initially appointed, Lordship, in 21/1995, Lordship, as a data entry operator, and he was continuing as a data entry operator since 1995 to 2001, Lordship.
Very good. CMC is very super. Heard Sri S. Borman, Learned Counsel for the petitioner. Also heard Sri K. Gogoi, Learned Standing Counsel, Higher Education Department. Anyone else? Government is there?
Right, Apuna?
Higher Education. No, Personnel Department.
Personal department. Personal, thank you.
MS Leaders Borman, State Council, appearing for the Personnel Department. The petitioner, the grievance of the petitioner is with regard to non-consideration of his case for promotion to the post of lecturer of Polytechnic Institute, which was under consideration in a DPC constituted on 27/1/2016. The case of the petitioner is that he had passed, and he had initially obtained a 3 years diploma course in computer engineering, and thereafter had obtained the BE Tech in computer science and engineering, and having long experience as data entry operator and senior instructor. Full stop. The petitioner claims to be eligible for promotion to the post of lecturer under the Assam Technical Education Service rules, junior rules, 1984, and also eligible under the Assam Technical Education Service Rule 1981. Full stop. The petitioner claims to have possessed all the requisite qualifications and experience under those rules. Full stop. However, provide the minute of the DPC, which had sat on 27/1/2016, while the cases of other candidates were considered, the petitioner was left out. Full stop. Para. The Burman, the learned counsel for the petitioner, submit that the petitioner claims all the requisite qualifications as per the rules of 1981. Full stop. He further submits that the OM Office Memorandum of 2004, which was published by the government department, pertains only to direct recruitment and cannot be made applicable to the cases of promotion. Full stop. It is further submitted that the AICTE notification is applicable from the stage of lecturer and not prior to that, and therefore in a case for consideration of promotion to the post of lecturer, there would be no application of such notification. Also, in any case, the learned counsel submits that such notification is not meant for promotion and should be confined only to direct recruitment. Full stop. The Burman, the learned counsel, has also relied upon a judgment and order dated 1/8/2016 passed by this court in WPC 3327 of 2011. Full stop. In the state case, it is the contention of the petitioner that in the state case, a similarly situated person was given the benefit of promotion and appropriate direction issued in that regard. Full stop. The learned counsel prays that a similar direction be issued in the present case also. Full stop. Per contrast, Sri K. Gogoi, the learned standing counsel, Higher Education Department, has submitted that refuting the allegations and claim of the petitioner, an affidavit in opposition has been filed on 9/12/2020 Full stop. By drawing the attention of Rule 11 of the rules of 1981, the Learned Council submits that the said rule was amended by amended in the year 2008, by which certain clauses were substituted. Full stop. By drawing the attention of this court to by drawing the attention of this court to Rule 11, within bracket 3, comma, the Standing Council submits that there is a requirement to have an experience of a minimum period of 8 years on the 1st of January of the year of promotion. Under subclause C, comma, the candidate is required to possess the qualification and experience as prescribed for the cadre of lecturer, polytechnic, as prescribed by the AICTE from time to time, as adopted by the government of Assam. Full stop. Reference has been made to Rule 11 within bracket 1 to contend that the procedure prescribed in Rules 13 and 14 with regard to the mode of promotion would also be applicable for promotion to the post of lecturer under Rule 11. Full stop. By drawing the attention of this court to the office memorandum dated 18 January 2016, issued by the Higher Education within bracket Technical Department, comma, Government of Assam, comma, the Learned Standing Council has submitted that the qualification is prescribed as bachelor's degree in engineering oblique technology in the relevant branch with first class or equivalent. Full stop.
In respect to AICT notice, page 137. AICT notification was annexed there with notice.
Yes.
Page 137.
One thing.
Sure.
137 of your
137 of the disposition notice. The AICT notification 2010, which was applicable at that relevant point of time.
the Learned State Council has also referred to The Gazette notification dated 5/3/2010 of the AICTE, wherein the minimum qualification and experience has been laid down, and in case of lecturer, comma, such qualification has been stated to be first class or equivalent in the relevant branch. Full stop. The Learned Standing Council has submitted that it appears from the record that the petitioner had rendered service for a major period from 17/8/2006 to 28/6/2017 as an LDA, and only for a brief period from 28/6/2017 to 1/8/2017, comma, he has served in the computer sector. Therefore, the Learned Standing Council contends that second class boli kono nahi, mone hai na second class boli tar upor eta. Sri Gogoi submits that the petitioner is a second class in computer science in his BTech. After qualification raheba. The Learned Standing Council accordingly submits that both on account of lack of qualification as well as lack of experience as prescribed by the rule, comma, the petitioner does not come into the zone of consideration for such promotion. Full stop. With regard to the judgment of this court relied upon by the petitioner, comma, the Learned Standing Council has submitted that the said judgment pertained to a DPC which was conducted on 27/1/2006, when the amendment had not even come into operation. On the other hand, comma, in the instant case, comma, the consideration was made in the year 2016, when the amendment and the office memorandum had already come into operation. He accordingly submits that the situation in which the earlier order dated 1/8/2016 in WPC 3327 of 2011 was passed, comma, the situation was entirely different and cannot be equated with the present case. Full stop. The rival submissions made by the Learned Council for the parties have been duly considered, and the material placed before the court have been carefully examined. Full stop. The primary contention of the petitioner, comma, as recorded above, is that the OM of 2004 is not applicable in the case of promotion and is only for direct recruitment. Full stop. He further submits that under the 1981 rule, he has all the qualifications and therefore his case ought to have been considered in the DPC held on 27/1/2016 and accordingly be given promotion to the post of lecturer. The aforesaid contention, however, has to be tested with regard to the statutory rules governing the field. The rules of 1981 lays down the provisions for recruitment by promotion as lecturer in polytechnic, which is found in Rule 11. Full stop. Under Rule 11(3), the feeder cadres have been stated from which such promotions are to be made, and the eligibility has also been laid down. Full stop. For ready reference, Rule 11 within bracket 3 is extracted herein below. Full stop. It is seen that there is a requirement of rendering service in the respective cadre for a minimum period of 8 years, and the qualification is required to be, and the qualification and experience is required to be as prescribed for the cadre of lecturer polytechnic as prescribed by the AICTE. Full stop. The said rule was amended in the year 2008, and once the requirement of qualification and experience as prescribed by the AICTE is made a part of the statute, this court is unable to accept the contention made on behalf of the petitioner that such qualification and experience would not be applicable in case of promotion and should be confined only to direct recruitment. Full stop. In fact, Rule 11, as noted above, is pertaining to recruitment by promotion as lecturer. Full stop. This court also finds force in the contention made on behalf of the department that the notification dated 5/3/2010 of the AICTE clearly lays down the qualification to be bachelor's degree in engineering / technology in the relevant branch with first class or equivalent. And in the instead case, it is not in dispute that the petitioner is not a first class in his B.Tech and is only a second class. Full stop. The materials on record would also show that the petitioner lacks the minimum experience of 8 years in the discipline of computer science, as he had served barely for 2 months under the said discipline in the feeder cadre. Full stop. Para. With regard to the earlier judgment of this court passed in WPC 3327/2011, 3 Gogoi, the learned pending counsel, appears to be correct in contending that the said judgment was rendered vis-a-vis a DPC held on 27/1/2006, which was much prior to the amendment, and the present case is on the basis of a DPC dated 27/1/2016, when the amendment brought in the year 2008 was already operating. Under those aforesaid facts and circumstances, this court is of the opinion that no case for interference is made out, and accordingly, the writ petition stands dismissed. We have recorded your name. What is this? Yeah.
My lord, this is also a matter of selection and appointment in the post of a lower division assistant, my lord, in a senior madrasa, my lord, at that relevant period of time. Now, my lord, this has been converted, my lord, to
High school.
it is in high school. My lord, what has happened on the last 2 occasions, my lord, I prayed before my lordship for, my lord, time to file my rejoinder, my lord. What has happened, my lord, the petitioner, I have put somehow contact him, my lord, he is out of station. So, my lord, this rejoinder affidavit, though I have prepared, I could not file it. So, my lord, can, my lord, be taken up after the vacation, my lord? And my lord may be pleased to take up.
You have made the observation.
My lord.
On that day, irrespective of the fact as to
Yes,
whether
yes.
such rejoinder is filed or
My lord,
16 matter, it not looked good. Yes.
my lord. My lord, also I am not want to, my lord, proceed in this manner, my lord. My lord, what has happened? An advertisement has been floated, my lord. My lord may be pleased to find.
Who is for the other side? BTC.
My lord,
No, my
no,
lord.
no, my lord.
I am appearing for respondent number 9.
Who is for a department?
I'm
BTC is also there. BTC is there. No.
Please,
for respondent number 9. Private.
Now, my lord,
Yes, tell us the fact. We are taking for disposal 16
yes,
matters.
yes, sir.
Yes.
My lord, what has happened? Initially, these posts were tried to be filled up.
Which what
This
post? Post of?
post of, my lord, what has happened, my lord? Initially, both the teaching and non-teaching staff, my lord, in the
Of Madrasa.
for madrasas in the entire state of Assam, my lord, government has initiated a process for the purpose of filling up the post available in the vacant post in all these categories of institutions, my lord. And but, my lord, due to certain reasons, my lord, the very notification dated 12/9/2012, my lord, which was the basis for this, my lord, recruitment process in the
12/9?
12/9/2012, my lord.
Was it a policy or
Yeah, my lord, what has happened, my lord,
decision to fill up post?
my lord, what has happened, my lord, these madrasas were provincialized in the year 1995 by way of the Assam Madrasa Education Provincialization Act of 1995, my lord. And Section 5 deals with the method and procedure for the purpose of filling up of these vacant posts. But, my lord, though there is a policy for framing of recruitment rules, my lord, till 2017, no recruitment rules had been framed, and they are following the rules of 2000, my lord, this secondary level institution, that is the Assam provincialized secondary education rules of 2003, my lord, at that relevant period of time. Now, my lord, when this 12/9/2012 policy was incorporated for the purpose of, my lord, filling up of the vacant post, then a PIL had been come up, my lord, before this honorable court. More particularly for the teaching post, my lord, that these teachers is required to be, my lord, NCT qualified, and as the state has proceeded, my lord, without the NCT qualification, that is STEP and other mandatory qualification, therefore the entire recruitment process vitiated in law. Accordingly, my lord, the government has acceded to the prayer made in the PIL, and my lord, has revoked the entire selection process in the entire state, my lord. Just for a moment, my lord, I have annexed the order passed in the PIL, my lord. My lord may be pleased to find, my lord, at page 36 of my writ petition, my lord.
36.
36, my lord. Annexure 3 part, my lord.
Yes.
My lord, I am reading the paragraph from Learned Additional Advocate General at the outset. Stated
This is
that
PL number 48.
no, my lord, it is in
PL
my,
number 48.
yes, my lord, it is in my petition. I am reading page number 36. my lord.
PL number 48.
48. Yes, my lord. Yes, my lord. That is in page 36, paragraph Learned Additional Advocate General, my lord. I am reading, my lord.
At 36.
Yes, my lord.
Yes.
Learned Additional Advocate General at the outset stated that the selection process of 470 teachers for the provincialized Madrasa institutions all over the state, which was impugned in the writ petition by means of this PIL, has since been revoked by the state government by their order dated 21/12/2013. He also stated that consequent upon the revocation, the state government has now further taken a decision to introduce the teachers eligibility test for the recruitment of the teachers in this provincialized Madrasa institution. We record this statement of the Learned Additional Advocate General made by him for and on behalf of the state of Assam, and accordingly dismiss this writ petition as having been rendered infructuous, because in our considered view, the very purpose for which this PIL was filed appears to have been achieved, or we would say no longer survive for adjudication. We need not burden our order by mentioning the facts pleaded in this petition in details in the light of the statement made by Mr. So-and-so, Learned Additional Advocate General, on behalf of the state government as aforesaid. Before parting with the case, we wish to record that the above statement made by the Learned Additional Advocate General on behalf of the state shall be complied with in the letter and spirit by the state, while making recruitment of the teachers of the concerned institution strictly on the basis of the norms set out for selection. No cause. Lord, what has happened? Basically, though this grievance was against the teaching post, Milord, in that recruitment process of 470 numbers, Milord, this non-teaching staff were also included, Milord. As a result, Milord, what has happened? The entire recruitment process of, Milord, teaching and non-teaching staff had been revoked by the government. Then, Milord, although there is a, Milord, statement made that it will be carried out in letter and spirit, but it had not been done, then a contempt petition has been filed, Milord, at page 37. And this honorable court disposed of the contempt petition, giving liberty, extending another 6 months time to comply with the order, and the contempt had been, Milord, closed. Now, Milord, at page
One second.
My lord.
2614.
My lord, page
Another 6 months.
yes, my lord. My lord, yes, my lord. It can be, my lord, verified by my lord. Another 6 months period has been extended, my lord. My lord, at paragraph 6, my lord, passed by the division bench, if this court in PIL number shall have to be complied with in letter and by within 6 months from the date of this order. First few line from the top, my lord.
Yes.
My lord. Accordingly, my lord, the government, on the one hand, my lord, conducted the teacher eligibility test for the purpose of recruitment of the teaching staff, and on the other hand, my lord, initiated a process for the purpose of filling up of the non-teaching category, and the notification had been issued. My lord, may be pleased to find the notification is at page 41, my lord, annex of 5.
Okay.
Annex of 5, page 41. My lord, God, my lord, it has gone. My lord, yes, this is the notification, my lord. Subject, my lord, filling up of the sanctioned vacant post of junior assistant and librarian and procedure for selection and appointment of candidate in provincialized Madrasa institution under the Directorate of Madrasa Education Assam. My lord, this is the detailed guideline and the criteria had been, my lord, formulated, and my lord may be pleased to find one thing from this notification, my lord, at clause 1, as per section 2 of the subsection 5 of the Assam Madrasa Education Provincialization Act of 1995, a selection board shall be constituted by the Managing Committee of the School Management and Development Committee of the Senior Madrasa and the Governing Body SMDC of the Title Madrasa and Arabic Colleges as stated below. So, my lord, this is the criteria has been laid down in accordance with the provision of section 5, subsection 2. Here, my lord, I want to pause just for a moment, and I want to bring my lordship, my lord, previous attention to the section 5, subsection 2 of the 1995 Act, which my lord may be pleased to find at page 392 of this book, my lord. My lord, this is same book, my lord. Page 392. Section 5, my lord, subsection 2 at page 396.
Assam,
Madrasa Education Provincialization Act of 1995. My lord, as on date, this act has already been repealed, my lord, revoked. But at that time, my lord, it was governing.
what happened there?
My lord, yes, my lord, I want to bring, my lord, kind notice of this provision, my lord. This selection for recruitment
Which one?
at page 396, my lord.
Provision number
Provision of section 5, subsection 2, my lord.
5.2.
My lord. This selection, my lord.
Government to take over madrasa.
No, my lord, this is not. I am referring to 5.2, my lord. Subsection 2, my lord.
Selection for recruitment.
Yes, my lord. The selection for recruitment to any post, teaching or non-teaching, in a madrasa, except the post of superintendent of a senior madrasa and principal of a title madrasa on Arabic college, shall be made by a selection board, which shall be constituted by the president of the managing committee of the governing body, as the case may be, of the madrasa for each such madrasa stated below. My lord, the selection for recruitment is required to be made by this selection committee, my lord.
Yes.
So, my lord, but herein what they have done, my lord, after constituting this, if my lord may be pleased to peruse the later part, my lord, in respect of so and so madrasa, clause 2, my lord, as per the existing rules, and shall be constituted as per the existing rule and provision, the selection shall not be valid in so and so, the selection board will remain valid. Then, my lord, the records minutes of this shall be maintained in written format, so and so. The selection list will be prepared for the exact number of vacancies to be filled up and not access for the so and so. These are the conditions they have prepared, my lord. And on receipt of application, selection board of the concerned institution shall hold interview and complete the selection process within 1 week, and then shall prepare the merit select list following the criteria of the point scale as indicated below. For selection of the applicant, the respective.
Where are you reading this?
My lord, I am reading at page, my lord, 41 and 42 of my petition.
Readings.
Readings. My lord, got it, my lord.
And what are you trying to
My lord,
contend?
I am, my lord, on this, that the statute does not say, my lord, that after this constitution of the selection, my lord, who will make the appointment. But the government has, my lord, by suo motu, has formulated this rule in violation of the, my lord, rule and procedure which is already there under the 2003 rule. Because, my lord, as the government has in a pleading, my lord, before this honorable court, has on affidavit said that in absence of the specific service rules, we are following the 2003 my lord, secondary education provincialized service rule. For that, my lord, I beg to draw my lordship's kind attention to one of the, my lord, page of my pleading, my lord. Starts from page 52, my lord, an affidavit filed by the commissioner, my lord, who was at that relevant period of time in one of the writ petition of similar nature, my lord. At page 62, my lord, may be pleased to verify, my lord.
52.
62, my lord.
Affidavit starts at 52.
Yes, yes, my lord. This is an affidavit. It starts at 52, and our, my lord, relevant part for this cause, my lord, is at page 62, my lord.
It's a part of your pleadings.
Yes, my lord. Part of
It
my
was filed in which another case.
another case, my lord, by the government, wherein, my lord, government has stated in on oath that the 2003 service rule is applicable, my lord.
Where?
My lord, in subpara, it is further word
Page.
page 62. I am relying.
62.
62, my lord. My lord, in page 52, the second paragraph, subpara, my lord, it is further worth mentioning here that Section 3A of the Act of 1995 confers power upon the government to apply and or take recourse of the service rule which is applicable to the corresponding grade employees at par to these madrasas employees. As these categories of institutions are secondary level, the Assam Secondary Education Provincialization Service Rule 2003 has been applied for the purpose of recruitment of teachers in this madrasa institution. As such, the contention made in so and so. So, my lord, it is a very specific and categorically said, my lord, that in absence there is no rule. So, therefore, my lord, we are following the 2003.
So what about the 95 rules?
No, my lord, this 95 rules has not said, my lord, it is not a rule, my lord. This is an statute. This is a provincialization act, my lord. If my lord may be pleased to take up the act again, my lord, at page 390 to section 8. Section 8, my lord, may kindly verify, my lord. This act is specifically for the purpose of provincialization of, my lord, employees who were at the venture stage at that relevant period of time. Now, section 8 of this said, my lord, power to make rules. The government may by not at page 398.
Yes, yes.
My lord. The government may by notification in the official gazette make rules for carrying out the provision of this act. Every rule made under this section shall, as soon as may be after they are made, be laid before the Assam Legislative Assembly while it is in session for a total period of not less than 14 days, which may be comprised in one session or two or more successive sessions, and if before the expiry of the session in which it is so laid, or the session immediately following, the Assam Legislative Assembly agreed that the rule should not be made, the rules shall thereafter have.
You did not read this. Rules have not been made.
No, yes, my lord.
You did not read this.
By applying this provision of section 8, my lord, till 2017, they have not made any rule, my lord. So therefore, the government was following this corresponding service rule of 2003, my lord. Because, my lord, the cadre, the nature of, my lord, appointment as well as the recruitment, the qualification, everything was same. Even the payment scale was also same for the madrasa as well as the high school level employees, corresponding grade. So now, my lord, when there is a rule is already there, as per the stand of the government, this notification, my lord, executive instruction which they have come up, which I have just brought into my lordship, can notice this executive instruction is at page 26th of November 2015, is, my lord, is an attempt or an act, my lord, which is an overriding effect on the 2003 service rule. Because the 2003 service rule is very specific, my lord, that in what manner the non-teaching.
Just a minute. Let us read 5 of Rule 5.
Yes.
I mean, Section 5.
Section 5, my lord, government to take over madrasas and employees, my lord, with effect from the appointed day, the administration, management, and control of all employees of all madrasa, the services of whose employees are provincialized under the provision of.
Under 5(2), a detailed procedure has been given.
No, detailed procedure has been given, my lord.
Even in absence of a rule, isn't this a statute? The main statute is there. And the statute has provided how a selection of this to be made. Only because rules are not made, will you have a case?
No, my lord, the rules are there, my lord.
No, rules under, you said that under 1995, rules have not been framed.
Not been framed,
But when the statute itself, the act itself, lays down the procedure,
my lord.
how a non-teaching staff is to be appointed
My lord.
by a selection board. Only because rules have not been framed, the act will not be applicable.
This act, my lord. No,
In 95 Act.
No, 95 Act is applicable, my lord. I am not saying that 95 Act
No,
is
you have
not
said that
applicable.
see, all along 2003 rules are being followed. So 95 Act will not have any application.
No, this is not my lord, my stand relying on the affidavit of the government filed before this honorable
Understood,
court.
but will
My
the affidavit be sacrosanct when we see that the statute contains a provision
My lord,
how a selection is to be made?
no, my lord, the statute said, my lord, if my lordship permits me, may I read
Yes,
over
yes,
again?
please.
Section 2, subsection 2 says, my lord, the selection for recruitment to any post, teaching or non-teaching in a madrasa, except the post of superintendent of a senior madrasa and principal of a title madrasa or an Arabic college shall be made by a selection board. My lord, may kindly note, the selection board can make,
Yes.
which shall be constituted by the president of the managing committee of the governing body, as the case may be of the madrasa for each such madrasa stated below. Now, if you go through the rule, my lord, who will make the selection board? They shall be constituted by the president of the managing committee of the governing body, as the case may be. Now, my lord, who has constituted this selection board? My lord, may kindly see, the government has constituted the selection board, my lord. That is another issue, my lord, may examine me. Statute says the selection board shall be constituted by the president. Now, here, if we come, my lord, this selection board has been constituted by the government, and it also requires an approval of the government, my lord, which is a my lord, enforcement over this section 5 subsection 2 by the government.
No, are you the managing committee? Who are you?
I am the one of the candidate, my lord. I am.
How are you bothered?
No, because
Has the managing committee come up to the court and said that our powers have been usurped?
No, my lord. I bothered because, my lord, I have been deprived by a selection board which has not been duly constituted in accordance with law, my lord. That's why, my lord, it is my contention, my lord, that I have been.
Selection committee has been constituted by the government department.
No, department cannot constitute.
It's not a private selection body that somebody picked and choose.
My lord, it is my with all respect, my lord, my contention is not that, my lord. My lord.
See, your submission we have to test with the facts and circumstances.
No, facts.
You may be correct in submitting that when the rules prescribe that the managing committee has to select, managing committee has not is not before us. You say that the selection committee is not being constituted under 5(2). We have to test that who has committee, what selection committee, who has constituted the selection committee, who are part of the selection committee. Ultimately, it's the fairness and transparency.
No, my lord, the rule of the law, my lord, the rule of the law, which is the, as my lordship has already said, my lord, that this section 5 subsection 2 is there. Then, my lord, if this section 5 subsection 2 is required to be applied, my lord, then it is required to be applied in toto, my lord. You cannot adopt the one part.
Now, where is the selection committee? Let us see.
Now, my lord, this selection committee, my lord.
What is your grievance before that? What is your grievance?
My grievance is, my lord, that this selection.
How many of you are there?
No, I am the only one candidate, my lord. I am only one candidate for the post of lower division assistant. And my lord, as this provision of viva voce and other was not there in the rule, now they have come up with the provision of viva voce, my lord. And by the exceeding of the viva voce mark, I have been ousted, my lord, on merit, my lord.
Where?
My lord, may be pleased to verify from the affidavit filed by my learned friend, my lord.
No, in your writ petition, what have you
No, my
stated?
lord, in my writ, it is not available because at that time I could not get access of the merit list. My lord, may be pleased to find the merit list at page 82 of the. Page 82 of the, my lord, affidavit in opposition filed by the private respondent, my lord.
Page 82.
Yes, my lord. Yes, my lord. And the, my lord, the select list at page 82, serial number 1 is the person who has already been appointed and whose appointment is under challenge before my lordship, my lord.
Serial number 1,
Serial number
Anis Jaman.
Zaman. If my lord may be pleased to verify, my lord, these marks at my lord page viva, my lord, out of 25, he has been given 25 and I was given only 20, my lord, out of 25.
You are Salauddin.
I am Salahuddin, my lord.
Salauddin is petitioner.
Serial number 3.
And Anis Jaman is respondent.
Respondent number 9. He has been given, my lord, 25, and I was given only 20, my lord.
Date of birth.
And, my lord, another
Which is
thing
at
is this
36, 38.
computer diploma, my lord.
Hmm.
This computer diploma
But
certificate.
Moniur Rahman has also got more than you.
No, that is correct, my lord, but he is not here. He is not here, and his viva voce mark, my lord, may kindly verify. Only given 2, my lord.
No. Even if you suppose, assuming you make out a case,
My lord.
and Moniur is above you.
Correct, my lord. On merit, my lord, I have no case. If we, my lord, the
See,
law,
we are not deciding a case only for academic purpose,
my lord.
unless you get some fruits of the litigation.
No, academic.
We
my
don't
lord,
have that much of liberty and time. We have that much of luxury to
no, my
decide
lord,
academic matters when pendency is up till 2013-12.
my lord, my lord, I am not.
Have you met Moniur Rahman party?
No, he is not a party here. Not a party. My lord, my case is very simple, my lord, that the rule which has been prescribed, they have not followed the provision of the rule and come up with their own rule in violation of the law, my lord. And now they have come up with this merit list, my lord, which is not supported by the rule of law, my lord. That is my case, my lord. Thus, my lord, they will make their own rule and follow with this, my lord, and it is not permissible, my lord.
Who was in the selection? Let us see the constitutional selection board.
My lord, this constitution of the board, my lord, the government has not filed any affidavit, my lord.
No, where have you stated? Who were in the board?
My lord. No, my lord, the board, I do not have the, my lord, this grievance against the member of the board, my lord. Against the member of the board, I do not have the grievance. But the board which the government has constituted, government has no power to constitute.
Let us see the board. Where is the
My
constitution?
lord, that board, my lord, particular board is not here on record, my lord.
How have you filed this writ petition?
My lord?
You don't have the basic documents.
No, my lord,
Your challenge is based on the fact that the selection committee is not as per law. Where is the selection committee? We do not know.
my lord, the government has not filed any affidavit.
Why should
my
your
lord.
burden go on the
My lord,
government?
I have
When
specifically.
you discharge, you don't discharge your own burden.
No, my lord, I have stated in my.
The onus will go upon them only when you discharge your burden first. Onus will not shift like this.
No, my lord, I am not shifting my onus, my lord. I have stated in details in my affidavit, in my pleadings, my lord. That
Where?
regarding the,
Where?
my lord, may kindly please to verify.
Where? Age?
Yes, my lord. That, my lord, page number 15.
1-5.
1-5,
Yes.
paragraph 15, my lord. Paragraph 14 and 15, my lord.
Yes, please read.
That the petitioner respectfully begs to state that the entire selection process carried out as well as in so Madrasa are vitiated in law, as much as the same has been carried out in violation of the provision of the Assam Madrasa Education Provincialization Act 1995, as well as the so Act, along with the non-application of the reservation law so. Therefore, the said deviation from the parent notification dated 26 and the advertisement dated made the entire selection process void ab initio. That in the present context of the case, the petitioner further begs to state that and submit that the madrasas are the secondary level school and which are provincialized in the year 1995 by the government by enacting the Assam Madrasa Education Provincialization Act of
Yeah, these are statement of laws. Where is the factual disclosure?
Factual dispute, my lord, I have said that.
Where is the disclosure of facts? Where have you stated? These are the members of the board. They are not constituted by the. You have not even given the notification of constitution.
No, my lord, this the very 1995 Act which I have just brought into my lordship notice, my lord, has said that the committee shall be constituted.
Where is the committee?
Committee, my lord, they have carried out with the committee this notification reveals.
Where have you stated?
No, my lord, this very notification at page 41, my lord, Annexure 5, which I have brought, my lord, as
page
41, my lord.
41.
My lord.
41.
41, my lord.
Yes.
It says, my lord, that as per section 2 of subsection 5 of the so-and-so Act of 1995, a selection board shall be constituted by the managing committee, school managing committee of the senior madrasa, title madrasa as stated below. Now, my lord, this committee which is required to be constituted by the school management committee, but the government has constituted the committee, my lord. Now that committee, obviously, my lord, I could not brought on record.
Now, who are the members?
My lord, the president of the
President of the managing committee.
president, my lord,
What is the
superintendent-
difference substantial?
No.
What substantial prejudice are you suffering, Mr. Bhuya? You are wasting the court's time.
No, my lord,
See the committee. Now we are seeing that it's almost the same perimeter of what the rules have stated.
It is the manner in which required to be done, my lord. For a particular madrasa, my lord, they have constituted a separate committee, my lord.
So president of the managing committee is there,
My lord.
superintendent of madrasa is there, principal is there, 2 academicians. What is the challenge? Yes, department. We thought we had a case very badly drafted and I don't think you should have filed this case. This is not how is structured petition.
The
Yes.
notification which is referred by my learned
41.
my lord, 41 page, is similar to the committee prescribed in the rules, my lord. One president of the managing committee, then B, my lord, superintendent of senior madrasa, is the member secretary, my lord, then member, 2 academician, then 2 members selected by the managing committee, and 1 representative to be nominated by the director of madrasa. Here also, my lord, in the rules also, my lord, the same in the act.
Let us see the act.
Yes, my lord.
President of managing committee
Yes, my lord.
of the senior madrasa.
Yes. Then superintendent of senior madrasa or the principal,
Superintendent of superintendent madrasa, 2
2
academicians,
academician, my lord.
2 members.
2 members. Then 1 represented by the deputy director of madrasa.
What else do you need?
This is the notification, my lord.
My lord, the constitution of the committee, my lord, is required to be done by the president of the managing committee. Now the government has constituted, my lord, government has taken over the power that who will be the member.
Are the members, is there any substantial difference with the members?
Once the government will
Sorry.
and secondly, my lord,
Sorry,
another,
this is not the purpose of our petition. Yes, anything else?
my lord,
Well,
another
Maybe a case for imposition of heavy cost. Maybe. Yes.
There is no challenge to this notification, my lord. My lord,
This
kindly see-
notification is not challenged.
No, my lord. Kindly see the prayer, my lord.
my lord,
Page 27. To set aside was the selection process carried out in Rupoi Senior Madrasa pursuant to the notification dated 26/11/2015 and advertisement dated 8/12/2015. Then, my lord, select list, then revoke the appointment of respondent number 9, my lord. There is no challenge to the notification, my lord. And, my lord, he is referring to the affidavit filed by the state at page 62, my lord, where he is contending that we are following the 2003 rules when rules are there is no rule in case of madrasa, my lord. Here, my lord, kindly see the sub-paragraph, my lord. Page 62, my lord. It is further worth mentioning to here that Section 3A of the Act 1995 confers power upon the government to apply and obligate to take recourse of the service rules which is applicable to the corresponding grade employee as part to these madrasa employees. At these categories of institutional secondary level, the Assam Secondary Level Provincial and Service Rule 2003 has been applied for the purpose of recruitment of teachers in the madrasa institution. Here, it is a case of junior assistant, my lord, not the teacher, my lord.
Let us see 3A. Let us see 3. Subject to the,
page 394, my lord.
yes, yes.
3A.
Subject to,
My lord,
subject to the provisions of
Article
309.
309 of the Constitution, all employees of madrasas now covered by deficit grant in it under the shall be deemed to have become the employees of the government on and from the appointed day on the following terms and conditions. All rules, including the service rules and rules of conduct discipline, which are applicable to the government servants of corresponding grade, similarly placed shall be applicable to the employees of the madrasa. So, my lord, that's why this secondary rule 2003, my lord, they are following for the purpose of non-teaching staff also, my lord.
Here, my lord, we have mentioned only about teachers, my lord.
And
Because for the
second-
non-teaching staff, my lord, that notification already prescribed a criteria, my lord, how to select, my lord. And it is in consonance with the act, my lord. There is no deviation from the act.
Okay, anything else?
And, my lord, he has participated in the selection process, became unsuccessful, my lord. He has challenged the outcome of the selection process, my lord. He was aware of the notification, my lord. At the time of participation
that
in
is,
the
my lord,
selection process, my lord, he was aware of the notification, my lord.
Petition is always in the case of the service, my lord, when someone is not, my lord, selected, lord, he can always come to before my lordship, my lord, for consideration.
It is not a case, my lord, he was not aware of the
No,
constitutional
no,
selection committee.
it is, I am not saying, my lord, that I was not aware, but the, my lord, very procedure and the guideline, my lord, which is there, they have not, my lord, this, even the 2003 rule has also not.
Yes,
been-
anything,
Yes, my lord.
Mr. Abha,
Problem.
for R9,
For 9 months,
R9,
R9.
yes,
My learned friend from the government matter already has clarified that the recruitment process was done in accordance with the provisions of law, and specifically the notification dated 26 November 2015 matter.
Hmm.
None of the contentions of the petitioner matter are here in the prayer matter. Lordship, if for a moment have a look at the prayer portion, it makes it clear matter, 27 matter. Whatever contentions my learned friend has made, matter, none of them have been mentioned in the prayer matter. This is only for to share a certain what is was the notice dated 28/2016 in respect of selection of respondent number 9. Revoke and resign the appointment letter is in favor of the respondent 9. All prayers are confined to respondent number 9. This is not a public interest litigation matter challenging the rules and procedures matter. He has specifically come for the petitioner matter, and his prayer is confined to respondent number 9. Therefore, my lord, since the notification is not a subject matter of this petition, my lord,
are your qualifications or eligibility put to challenge?
not my lord. Nowhere it is mentioned, my lord, in the rate petition stating. That apart,
He
my
has
lord,
made an
there is a
allegation
serious
that
issue of
in
maintainability.
Viva will see, you have been given more marks.
It's up to the interview board, my lord. I have nothing to do. Since I was found eligible and I was found fit, my lord,
Okay.
the mark was.
Anything?
My lord, only one notification which I could not bring into my lord and notice, my lord. My lord, if my lordship is going to hell, my lord, that this 2003 rule is applicable, then there is another office memorandum, my lord, governing this, how, because, my lord, these categories of post of lower division assistant in a senior madrasa and, my lord, in the high school is equivalent post, my lord. And at this moment, my lord, these are all the high school level employees, my lord, as on date. But, my lord, admittedly in the year 2015, they are in a different stream, my lord. Now, this office memorandum, my lord, at page 71 is a, my lord, guideline
29 December.
my lord, 29th of December 2015, my lord. Before this, my lord, recruitment process took place, because, my lord, this notification is of 26th of November 2015, and this guideline came, my lord, on 29th of December 2015, my lord. Guidelines for the recruitment of the junior assistant in the provincial as higher secondary, high school, and high madrasa, my lord, with a view to ensure the proper
No,
process,
Mr.
my lord.
Your selection advertisement was when?
Lord, my advertisement, my lord, was after this, my lord, notification
It
of
was not after, it was 8/12.
my lord.
This is 29/12. How is it relevant?
No, my lord, this is a supplement to the original 2003 rules.
A notification which has come after the advertisement, how could you make it applicable?
No, my lord, this is the even in the rule also, my lord, this procedure is there, my lord.
Procedure I've already seen.
My lord.
This
2003 rule,
December, this is December 29 notification.
my lord.
The advertisement was of
That is correct, my lord, before the date of advertisement, but in the rules of 2003, my lord, this detailed procedure and guideline has been
we
there.
have concluded.
My
Pass
lord.
the judgment. To come back.
My lord, obliged.
Please have your seat.
Fine.
The legality and validity of a selection process for filling up of the post of LDA in the Rupohi Senior Madrasa in the district of Nagaon is the subject matter of challenge. Full stop. I have heard that Sri A.R. Bhiya, learned counsel for the petitioner. Full stop. I have also heard Ms. D. Das Gorman, learned state counsel, Sri N.J. Khatonier, learned standing counsel, secondary education department. Anyone else? Sri A. Chaliha, learned standing counsel, finance department. Yes, and Sri S.R. Rabha, learned counsel for the respond number
9, madam.
9. Full stop. Para. The Sri the case projected in the petition is that an advertisement was published on 8/12/2015 by the director of Madrasa Education for filling up the putting up of a post of LDA in the Rupohi Senior Madrasa along with other posts. Rupohi Senior Madrasa within bracket hereinafter the school, along with other posts. Full stop. The petitioner who claims to be eligible for such appointment had applied, and the interview was held on 17/12/2015, in which the petitioner claims to have fared well. Full stop. The petitioner, it is the case of the petitioner that without publishing any merit list, a select list dated 28/2/2016 was published by the director, whereby the SP number 9 was appointed in the said post. Full stop. It is the case of the petitioner that the SP number 9 is inferior to him in academics, in academic proficiency, and the selection is also filled with anomalies to favor blue-eyed candidates. Full stop. Para. Sri Bhuya, the learned counsel for the petitioner, submits that the selection process was conducted in violation of the Assam Madrasa Education Provincialization Act 1996, hereinafter Act of 1996.
95, my lord.
95.
Mine.
95. 95. More specifically, section 5, is it 2?
Yes, my lord.
Five-
subsection
5 2 thereof. Full stop. The petitioner also alleges violation of Rule 4 of the Assam Secondary Education within bracket provincialization, bracket closed, service rule 2003, full stop. This, the learned counsel submits that it is the specific case of the petitioner that the notification dated 26/11/2015, followed by the advertisement dated 8/12/2015, are in conflict with the educational qualification, with the qualification criteria under the Assam, under the rules of 2003. Full stop. It is further contended that the select list was published by the director, Madrasa Education, which was in violation of section 5(2) of the 1995 Act. Full stop. By drawing the attention of the Act of 1995, Sri Bhuya, the learned counsel, submits that section 8 gives the power to make rules, and till date rules are not being framed. Full stop. He submits that in absence of any service rule, the present selection could not have been made and is liable to be declared void ab initio. Full stop. Para. Giving a brief history of the case, the learned counsel for the petitioner has submitted that initially PIL 48 of 2013 was filed regarding insertion of necessary qualifications for teachers of madrasa, in which this court, by an order dated 22/1/2014, had disposed of the said PIL, recording the submission made on behalf of the state that such requirement would be introduced in as a part of the qualification. Full stop. The aforesaid order dated 22/1/2014 was, however, extended by an order dated 2/6/2014 by another 6 months. Full stop. By drawing the attention of the notification dated 26/11/2015, by which the selection committee was constituted, selection board was constituted, the learned counsel for the petitioner submits that such powers as per the Act of 1995 has been conferred to the president of the managing committee, who would constitute such selection board, and the impugn notification has not been issued by the president of the managing committee, but by the director, Madrasa Education, and therefore the entire selection stands vitiated. Full stop. The learned counsel has also drawn the attention of this court to an affidavit in opposition to an affidavit filed by the department in another writ petition, in which, under similar circumstances, it was stated that the 2003 rules are being applied. Full stop. Sri Bhuya reiterates that unless rules that rules have not been framed under the Act of 1995, and in absence of that, the selection board is required to be constituted by strictly following the mandate of Section 5A, which has not been done. Full stop. Drawing the attention of this court to the select list, he submits that in the viva voce, while the petitioner has been given 20 marks, the respondent number 9 has been given 25 marks, as a result of which the respondent number 9 had stole a march over the petitioner. Full stop. The learned counsel accordingly submits that the entire selection of the respondent number 9 be interfered with. Full stop. Per contra, Sri N.J. Khatunier, learned standing counsel of the department, has submitted that the present challenge pertains only to the selection and appointment of the respondent number 9, and in this regard, he draws the attention of this court to the prayer of the writ petition. Full stop. For ready reference, the prayer of the writ petition is expected here and below. 27, A to A. Full stop. The standing counsel submits that it is only the selection and appointment of the respondent number 9 which has been put to challenge, whereas the notification dated 26/11/2015, by which the selection board was constituted, is not the subject matter of challenge. Full stop. He submits that in absence of such challenge, the present challenge only to the selection and appointment of the respondent number 9 would be without any basis. Full stop. As regards the allegation of marks, of more marks being allotted to the respondent number 9 in the viva voce, the standing counsel submits that the selection does not consist of the marks obtained in viva voce only, and only 25 marks was allotted to the said segment. Full stop. He otherwise submits that allotment of marks were given by the members of the committee, which was duly constituted by notification dated 26/11/2015, and in absence of any allegation of bias with the committee members as party respondents, the said allegation is not liable to be entered into. Full stop. Para. The Khatonian has also raised the issue of waiver by contending that the petitioner had all along participated in the selection selection initiated by the advertisement dated 8/12/2015 with very well knowing about the constitution of the selection committee by notification dated 26/11/2015. There was no challenge at any prior point of time regarding any deficiency in such selection board. The petitioner, it is submitted that the petitioner who took a calculated risk cannot be allowed to challenge the selection process only because of the fact that he has come out unsuccessful. Full stop. In this regard, comma, para. 3. S.R. Abha, the Council for Response number 9, has endorsed the submission. No, S.R. Abha, what he did. MSD Das Burman, the State Council, has endorsed the submission of the Standing Council of the department. Full stop. Para. 3. S.R. Abha, the Council for the Response number 9, while endorsing and supporting the submission made on behalf of the department, has further submitted that the recruitment has been done in a fair manner as per the notification dated 26/11/2015, which, however, is not the subject matter of challenge. Full stop. He further submits that the eligibility and qualification of his client has not been questioned, and only his selection has been challenged without any prayer against the notification dated 26/11/2015. Full stop. Para. In his rejoinder, comma, Sri Bhuya has referred to an office memorandum dated 29/12/2015, issued by the department on the laying down the guidelines for recruitment of junior assistant in provincialized higher secondary and high schools / high madrasa. Para. The travel contentions made by the learned counsel for the parties have been duly considered. Full stop. The primary allegation, as would appear from the writ petition, is with the selection and appointment of the respondent number 9 as LDA of the school. Full stop. The prayer which has been quoted above would show that the challenge is confined only to the selection and appointment of the respondent number 9, and there is no challenge to the notification dated 26/11/2015 by which the selection board was constituted. Full stop. In view of the above, this court is actually not required to go into the aspect of the aspect of the legality of the said notification. Full stop. However, since an argument has been sought to be developed in the court during the hearing, this court, in the interest of justice, has also decided to take up the issue. Full stop. The primary allegation is that the notification dated 26/11/2015 is in teeth of the provision of section 5(2) of the Act of 1995. Full stop. The section 5(2), for the sake of convenience, section 5(2) is extracted herein below. Upper 5(2) here for election. Juxtaposed, let us have a look at the constitution of the selection board vide the notification dated 26/11/2015. On a reading of both the provision in the Act and the notification would show that the selection board is substantially selection board constituted is in substantial compliance of the requirement of 5(2). Full stop. The learned counsel for the petitioner has emphasized that the notification is issued by the director of Madrasa education and not by the president of the managing committee as per 5(2) of the Act. The aforesaid contention is not liable to be acceptable, as no prejudice, whatsoever has been suffered by the petitioner by the board, but in the manner of constitution of the board, which consists of members which is in tune, or which consists of members and is in tune with the requirement of section 5(2). Full stop. Further, the notification is issued by none other than the director of Madrasa education, in which of which the petitioner was fully aware and had never made any protest or objection. Full stop. The petitioner, having submitted to the jurisdiction of the board which was constituted by the notification dated 26/11/2015 and had all along participated in the selection process, cannot be allowed to make a volte-face and challenge the selection only on the ground that the board was constituted by an authority not stipulated by the rules, by the Act. Full stop. It is a settled law that normally, an unsuccessful candidate is not allowed to challenge a selection only because of the fact that he had come out unsuccessful. Full stop. In the case of Madan Lal versus State of J&K, reported in so and so, it has been laid down that unsuccessful candidate who had taken a calculated risk of participating in the selection process is not permitted to challenge the same only because he had come out unsuccessful. The aforesaid the case of Madan Lal has been followed in the later cases, including the case of Para. This court has also noticed that in the entire pleadings and the documents, there was no. Don't write this. The courts have also noticed that in the affidavit filed by the respondent number 9, the select list has been annexed as annexed 3, from which it reveals that the petitioner was in the third position and there is another candidate, Moinur Rahman, in the second position below the respondent number 9, who was placed at first position. Full stop. Para. No, not para. This court is of the opinion that if the stand taken by the learned counsel at the time of hearing with regard to the validity of the selection process initiated by the notification dated 26/11/2015 is to be accepted, the other selected candidate is also liable to be made a party, which has not been done. Further, even assuming that a case of interference would have been made out, only the selection of the respondent number 9 would be interfered, in which case also the petitioner will not get any fruits. And therefore, this court is of the opinion that the present is not a fit case for interference. The writ petition according to distance dismissed. Yes. Yes.
Petitioner is the petitioner. Petitioner is the Hindi teacher. Background of the case is that, my lord, in the year 1990, he was appointed as Hindi teacher by the school managing committee in a
Venture School, 1990.
90.
Okay.
And during the period of 91-92, my lord, there was a centrally sponsored scheme. Under that scheme, my lord, 500 posts were created by the state of Assam. And one post was allotted to that school, Poverty Girls High School, and I was appointed against that post in the year 1990. Subsequently, my lord, scheme was withdrawn, and thereafter, my lord, in the year 1999, my lord, in 1998, there was a screening test of all the Hindi teachers appointed under that scheme, my lord. And in the year 1999, that scheme was withdrawn, and all the 500 posts were abolished, and newly 401 numbers of new posts were created under non-planned method. And petitioner was appointed in the year 2000 against that one post, my lord. And out of that 401 post, my lord, 82 teachers were appointed in cancer school, and remaining 319 posts were, my lord, appointed in provincial school. And the teachers who were appointed in the provincial school, my lord, they were allowed the regular scale of pay. And the remaining 82 teachers who were appointed in the cancer school, my lord, they were allowed to draw fixed scale of payment.
To
Fixed scale of payment. In the year 2004, my lord, all those posts were permanently retained by a common order. And thereafter, my lord, in the year 2005, some of the teachers approached this honorable court for, my lord, similar benefit to their counterpart who were appointed in the provincial school. And this honorable court, my lord, issued a direction to the government, my lord, to consider the case. In the year 2007, my lord, an order has been passed by a committee, my lord, rejecting the claim of those petitioners, my lord, but decided to accommodate them in future, my lord, vacant post in provincial school. And accordingly, in the year 2009, out of 82 teachers, 76 teachers were, my lord, appointed in the provincial school, my lord, by way of regularization or adjustment. And I have been left out, my lord, because, my lord, in the year 2006, I was transferred by inspector of schools, my lord, on my request, my lord, to another school, that is my Polastal Customary School, which is a provincial school, against a sanctioned vacant post. And since then, my lord, I have not been received my salary. Thereafter, my lord, in the year 2000,
You are not receiving fixed salary also.
no, my lord, I have not received fixed salary also. Since then, after my transfer,
When was it?
my lord, I was transferred to Polastal Customary School in the year 2006, my lord, in the month of August,
6.
my lord. Thereafter, my lord, some communications were there with the government, my lord, and my regular proposal for regularization was also sent by director to the government, my lord, but that was not approved.
But you filed this in 18.
My lord, what happened in the year 2013, I approached this honorable court, my lord, when there was an advertisement, my lord, for the post against which I was transferred. And then this court, honorable court, my lord, state the advertisement, and ultimately in the year 2017, my lord, that case has been disposed, and with a direction to consider to pass a speaking order regarding my lord adjustment or regular.
Has it been passed?
It has been passed, my lord, in the year.
Where is it?
That has been challenged, my lord. That is, my lord, impugn order, page 85.
85.
85. And I have not been, my lord, allowed adjustment only due to not having paid my.
You have to rise. We'll continue. There's some meeting. We'll continue DSL too.
Judgment by this honorable court, my lord, we have approved the division bench, because, my lord, in that judgment, my lord, our salary part was declined. So division bench, my lord, allowed our current and area salary, but subject to, my lord, limitation of 3 years up before filing of the earlier case. And, my lord, during pendency of that writ appeal, this impugn order has been passed. And we, with the leave of the honorable division bench, my lord, we have amended the appeal, but, my lord, subsequently with liberty that has been disclosed, we were given liberty to approach this court, my lord, challenging this impugn order. And another relevant fact is that, my lord, in the meantime, some other batch of the similar, my lord, Hindi teachers, out of 82 teachers, my lord, they have approached this honorable court by filing WPC number 6279 of 2012. And that has also been, my lord, disposed of. That is, my lord, is at page 92, my lord. And the relevant portion is at page 110. Thereby, my lord, this honorable court allowed those 82 Hindi teachers who were appointed in, my lord, answer schools, the regular scale of pay, my lord, actually, my lord, equal treatment. It is declared that we are equal to other counterpart, my lord, who were, my lord, appointed in provincial. And thereafter, my lord, the government has taken the decision to allow them with retrospective effect the consequential benefit. but that order is not before this honorable court. And my lord, regarding my lord, the rejection of my claim due to not having TET, my lord, I have filed, my lord, the additional affidavit, my lord, that is on affidavit in reply, my lord. In this case, my lord, in the reply, my lord, I have amended one judgment, my lord, whereby, my lord, two similarly situated Hindi teachers approached this honorable court, and similar direction was issued to consider the case of those two petitioners, my lord, and they were allowed, my lord, the benefit by, that is page 140, my lord, annexure B. They also do not have, my lord, the TET. And this order was issued on 17th April 2017. And whereas, my lord, my claim has been rejected, order dated, my lord, 24/1/2007, only due to not having TET. So, my lord, my humble prayer before this honorable court is that I am within those 82 Hindi teachers, my lord. I was transferred to, my lord, a provincial school from government post to government post, my lord, by competent authority. But there was irregularity because, my lord, the post against which I was transferred, that was with regular scale of payment, and I was drawing only fixed scale of payment. That is why, my lord, that was irregular. But I was not reverted back to my earlier post in the meantime.
What do you say, Mr. Gautam?
The only reason, my lord, he was left out from the category of 82 teachers because in the meantime he applied for transfer and it was granted from a Fencer school to a provincial school. And while the verification was carried out, he was found that he was not available within this 82, my lord. That's why his case was not considered along with the 82, my lord. Subsequently, my lord, his case was rejected pursuant to this honorable court order, my lord, on the ground of he was not having the requisite qualification as required under the 2012 rules, my lord. But, my lord, in the meantime, my lord, while the case is pending, the direction was issued to file an affidavit, my lord, as regards the order is 22/2/2023. There's an order, my lord. Specific query was put to, my lord.
22?
22/2/2023, my lord. The query was whether the respondents have paid the petitioner her salary remuneration for the period from 1/7/2010 till the date of judgment dated 25/1/2018. Then whether the petitioner is still rendering her service at Polaskal Kasomari High School, and if so, to when the petitioner has been paid her remuneration fixed salary for the same. What steps have been taken by the respondent authorities pursuant to the order dated 24/1/2017 passed by the Commissioner and Secretary to the Government of Assam Secondary Education Department, whereby the petitioner's prayer for regularization was rejected on the ground that the petitioner did not have TET qualification on the said date. Pursuant thereto, my lord, we have filed an affidavit. In that affidavit, my lord, kindly come to page 143, my lord. Here, paragraph 3. Pursuant to the order dated 22/2/2023, the deponent has sought for a report from the Inspector of School Nagaon with regard to the queries put by this honorable court. Accordingly, the Inspector of School Nagaon, by letter dated 9/3/23, submitted its report. While answering to the first query put by this honorable court, the deponent humbly begs to state that the proposal for arrears salary with effect from 1/7/2010 was submitted by the Inspector of School by proposal dated 12/11/2020. Thereafter, the arrear proposal to the petitioner was forwarded to the government by dated 27/12/2021. That with regard to the second query of the honorable court, the deponent humbly begs to state that the petitioner is still rendering her service at Polaskal Kasomari High School regularly. As regards the payment of salary to the petitioner, the status of the same is explained in the following paragraph. With regard to the query regarding regularization of the service of the petitioner, the deponent humbly begs to state that the services of the petitioner were regularized, adjusted as Hindi teacher in Polastol Customary High School, white order dated 27/2/2020, with effect from 27/5/2020, and also directed to draw her salary with immediate effect. In this regard, the then Inspector of School directed the headmaster Polastol Customary High School to take necessary action. Accordingly, the headmaster of school of the said school draw and disburse her provisional monthly salary with effect from 27/5/2020 to 31/10/2020, and applied for the release of first salary in PIN Assam portal on 6/10/2020, seeking approval of the director. Accordingly, the proposal for the first salary of Srimati Beauty Rekha submitted to the government in so-and-so portal bearing proposal number so-and-so from this director but approval. But government raised objection as there is no specific order from the Honorable Court for regularization of the service of the petitioner Srimati Beauty Rekha as Hindi teacher of so-and-so school. So there is further development, my lord, that though I ordered it in 2017, our prayer for regulation was rejected. Subsequently, director on 27/2/2020, her service was regularized.
27/2/2020.
2020, my lord.
Are you aware?
On what basis our service was regularized? That has not been reflected in the affidavit.
From where are you making the statement?
But from an instruction, my lord.
Instruction.
Yes, my lord. From an instruction received from the director only.
But my lord, for regularization, there must be approval of the government matter. That is,
No, that is a requirement, but when it has come from the
My-
Planet Council,
My-
we seek instructions. We'll record his of the
Because in fact, my lord, in the instruction that I have to obtain instruction in this regard also. In the instruction last paragraph, my lord, in the meantime, the order number so and so passed by the then Director of Secondary Education Assam, regularizing service of Srimati so and so in so and so is prospective manner with effect on so, as it is mentioned in the order that the same was done in compliance of the direction of the Honorable Court. That order is not with me, my lord, that the regulation order. But in the order, it has been reflected that
okay. Heard the UK Das Planet Council for the petitioner. Also heard the NJ Khatonier Land Training Council, Secondary Education Department. Sri Khatonier has placed before this court a written instructions as issued by the
Director of Secondary Education, my lord.
Director of Secondary Education, Assam, whereby it has been informed that the services of the petitioner were regularized on
White order dated 27/5/2020
by order dated 27/5/2020.
with effect from that order. From the date of order.
The Land Standing Council, however, is not equipped with a copy of the state order. Sri Das, the Land Council for the petitioner, he submits that he is also not aware of any such development. Under those circumstances, this court is of the opinion that some time be granted to the Land Council for the parties to obtain appropriate instructions. List when
Vacation, my
18 matter. List immediately after the summer vacation. We'll fix a date.
Yes, ma'am.
19th
Yes, my lord.
on 19/7.
my lord, it may be some difficulties on our part to collect the regularization order.
At least get the information.
My lord,
I will obtain the order, my lord.
Order and what is the difficulty? If you can contact your client.
my lord, as per my latest instruction also, she is not aware. We have.
In fact, my lord, in our affidavit,
So she is not aware.
No, she is not aware.
in fact, in our affidavit, we have stated that we have released the salary for some.
No,
You get the copy.
Yes, my lord.
You get the copy and hand it over to.
I'll provide him, my lord.
And you will also get a copy of this order. Ask your client to pursue to get the regulation order.
my lord.
Obliged, Lordship.
Yes.
Only till the last order.
Hmm.
The last profession. If we have some doubt on page 121
Hmm.
order.
Yes.
Well, here I have received the inspection report. May I please apply?
It is there.
My lord, as per this communication, my lord, this is my lord.
What are the enclosures to your instructions?
My lord, this first letter is, my lord, that is 14 October 2011. This has been written by the Deputy Secretary to the Directorate in connection with the contempt case regarding, my lord, 164 2000 in CRP. They have stated in para 14 of their writ petition, my lord. Para 14 of the writ petition, that is, my lord, CRP number 422 2009. So with reference to the subject quoted above, I am directed to request you kindly to withdraw the order issued by you under memo number so dated 21/4/2011, as it has been issued after the Honorable High Court's order dated 24/2/2011 passed in case number CRP 422 2009, and also instruct the Deputy Inspector of School Filter to release salary as per the Honorable Court's order. But here, my lord, this CRP was filed only to, my lord, challenging the, my lord, in order of an IM, my lord. Miss case, my lord, at the time miss case, whereby, my lord,
Now, what was the controversy on the last occasion?
last occasion, only thing is that, my lord, we have a doubt that this letter was whether issued or not. This, my lord,
28/9.
28.
Now, what is your instruction?
My lord, here, this has been issued, my lord. That is the instruction, my lord.
So, what needs to be done now?
My, the submission is that, my lord, this order of the title should pass after the issuance of this letter. Title suit order and title appeal order. Title suit order was passed on
On 26/11/15 and 12/12/2018, my lord, when the salaries were not released.
Now, which one will be?
Forecast are you for whom?
I'm for respondent number 8, my lord.
Who are you?
I'm the headmaster of the school, my lord.
After amalgamation, my lord, I was in the ME school. But during pendency of this proceeding, my lord, the school got amalgamated.
But
He is the headmaster of the school.
Of the amalgamated school.
Amalgamated.
He was the headmaster of the high school, that means.
High school. High school.
And you were?
In the ME school.
You were the headmaster.
No. I was a teacher.
Then what is your plea, what is your claim now?
My claim is, my lord, after the amalgamation, because of these proceedings, I was not I was not allowed to be amalgamated.
Your services
My
were
son,
not less than the amalgamated school.
school, my lord.
Thereafter,
Thereafter, I come up before your lordship. Matter is pending. Now, my lord, I say because of this cancellation,
If they want to proceed again, whatever they want to do, they can. But because of this cancellation, my lord, for the period that is there, I'm entitled to my salary. Subject to what further decision the government will take, my lord.
May I? Malad, in paragraph 14, Malad, I for a moment I
Of
of the read. I read
1-4.
Yes, page number 8.
Yes.
That during the trial before the learned Munsaf number 1 Kachar, the petitioner filed a mistake case number 168 of 2008 for temporary mandatory injunction, which was rejected on 8/9/2009, challenging the said order passed in miscellaneous application. The petitioner preferred Miss Appeal number 13 of 2009 before the civil judge 1 Kachar, which was allowed by an order dated 27/11/2009, directing the authorities to release the payment of monthly salary of the petitioner. Challenging the state order dated 27/11/2009, the state preferred civil revision petition 422 of 2009 before this honorable court, which was disposed of on 24/2/2011, directing the trial court to dispose the title suit number 163 of 2008 within a period of 6 months, with a further direction to the state to release the current salary of the petitioner till disposal of the suit. As the state did not comply with the said order, the petitioner preferred the contempt case number 163 of 2011. Upon receiving the notice of the contempt case, the state filed review petition number 103 of 2011 against the order dated 24/2/2011 passed in CRP number 422 of 2009. This honorable court was pleased to review the said order, directing only to dispose the title suit number 163 of 2008 within a period of 6 months. The direction of salary, my lord, release of salary, that has been modified by this honorable court with an object to face the trial court case, my lord. That is disposed of. And this direction, what my learned friend has produced, my lord, this says, with reference to the subject cited quoted above, I am directed to request you kindly to withdraw the order issued by you under memo number such and such dated 21/4/2011, as it has been issued after the honorable court's order dated 24/2/2011 passed in CRP number such and such. This CRP order has been modified, my lord, and ultimately it is culminated with the outcome of this title suit and title ethics. Now at this stage, my lord, whether in existence of the judgment of this honorable court through that direction after the direction in this civil CRP and the review petition, the title suit has been dismissed, title appeal has been dismissed. On merit, the honorable trial court has decided the issue. It is not that it is
Only thing, my friend can take whatever plea he wants. First thing, whether he's in service or not, I don't know. He filed an affidavit, he was 56 in 2019. Be the resident. Well, it's for the government to, I know, it's not a clear-cut case. There are many things here. But let the government take a decision, whatever decision they want, because what decision they took, that they have withdrawn, cancel, for whatever reason. Nobody has put that to challenge. Let them take that decision.
You are the headmaster.
He's the headmaster of the amalgamated school, and he came into being only in 2018. And these things have been of 2011.
honorable court has decided on the merit, and
My lord will have its affidavit.
Whether his salary is the issues framed by the my lord, the learned trial court, and the decisions thereupon has to be adjudicated in the RSA by framing the substantial question of law.
My lord, what I say is, I'm not even with that, my lord, even if that had come in my favor. Other way around. If the title suits had come in my favor, my lord, the state was not beyond its rights to take a plea that it's without this. So, my lord, the other way around also, that would be an issue. But the state, my lord, proceeded against it. I would say rightly, if I may use that as an officer of this court. But you having decided to withdraw it, you must now take a call. And that liberty will come from your lordship. Otherwise, they may not be.
No, if he is endorsing with your submission that the cancellation order was actually revoked, that is the instructions which he has.
Has, my lord.
Then what is there to be decided?
Nothing, my lord, because then the consequences will follow, my lord. And whatever is to be done, let them do, my lord. I don't know why the respondent number 8 is having so much of problem.
That's
The
some
appointment
personal
of the
enmity.
petitioner is illegal. My lord. That has been done by the SMC. My lord. SMC cannot appoint a teacher. My lord.
That is okay, but his cancellation,
My lord.
the order of cancellation of his appointment, you have withdrawn that.
My lord.
Why have you withdrawn?
It will. Yeah. It ought to have been, my lord, reviewed after the order of the review of this one. Order of this one will pass in that.
Last time you had rightly raised a doubt
My
that
lord.
it appears to be
My lord. Whether it is
not
genuine.
true. But your instruction says otherwise.
My lord. I asked the authority to verify properly. They have provided this. My lord. Here, my lord, petitioner was
See,
appointed.
by one point of looking, if we go by the trial court, civil case, then the title appeal, then it's a very easy way for us to say that this is not the right course of action. You could have challenged this in a second appeal. Naya says that he is not even touching this aspect of the matter. Since you yourself have taken a decision that you would be treated to be in service.
Even if, my lord, after, my lord, CRP, my lord, this order has passed. My lord. After passing this order in CRP, when this honorable court was directed to release the salary for 6 months, then, my lord, this order has been passed.
Page
In my instruction, my lord, that has been reflected from, my lord, the subject contempt case in CRP 422 of 2000. In issue number 4, my lord.
The director has already filed an affidavit earlier.
My lord, here we
Why
have,
didn't you clarify all these?
my lord, I have filed that affidavit, my lord. There, my lord, as per instruction, I have filed that. Only thing is that I have stated that that the school was provincialized in the year 1977. Well, at that point of time, after that, my lord, in the 1993, how can the SMC, my lord, appointed this that to honorary, my lord? That issue has been already discussed in page 68 of the title suit, my lord.
Let us come to the prayer again.
Lordship. My lord would have it at page 16, or page 15 it starts. I'm asking for a certiorari right, setting aside the letter dated 9/7/2018, issued by the deputy censor to declare so and so honest. That, my lord, I'm not pressing. B, not issued directing the respondents to release the current and arrears salary from July 2008 to the petitioner. And or be pleased to direct the petitioner to discharge the duties as assistant teacher of Tarapur Girls High School, being amalgamated with Tarapur Girls ME School. And that annexure 16, my lord, is, my lord, at page 49. And now, my lord, with the withdrawal and that thing, the inspect DI of schools, my lord, at that point of time, 22/8/2008, he had, my lord, raised these issues. My lord. Because my services were regularized, that was questioned, and that is how, my lord, that department proceeding was started against me.
This 9/7/2008,
Lordship,
which is the subject matter of challenge,
Lordship.
is by the deputy inspector of schools, right?
That was deputy inspector. Well, that was
And
converted.
headmistress was Mr. Purkasta's client was intimated. What was informed to you?
At that time, my lord, it was not amalgamated. It was ME school.
ME school.
Oh, that was in 2008.
8 months. Amalgamation was in February 2018. That was to the ME school.
Now what is the position?
Now I am hanging, my lord, because of this. Neither
You're
here nor-
working.
No, my lord.
No.
No.
But
I've not been allowed
what
to-
about the instructions?
They have been directing the school authorities to allow me, but my
No, what is the instruction?
to release my salaries, my lord, in 2011. It's the instruction. My lord, we'll have the second page, 4/11/2011.
Just a minute.
Yeah. 24 to 20. KRP dismissal. The review with disposal with 11.1 and 13 of clarity বন্ধ হয়েছে title 55 line.
In this instruction of 2023, he refers to orders of 2011.
My lord, we'll have that, my lord, at 4/11/2011.
Yes, that is it.
Here, my lord, it says, with reference to the subject cited above, I have the honor to state that the service termination order of so and so under District Elementary Education Kachar has been cancelled while this order dated so and so, and the DI of school Silchar has been requested several times by issuing letters and over phone to release the monthly salary of the petitioner.
Yes.
But the DI of schools is not willing to release the salary of the petitioner, and he has written a letter for clarification about the illegal appointment of the petitioner instead of release salary. Therefore, I would like to request the government to issue necessary instruction to the DI of schools, Silchar, to release the monthly salary of the petitioner in compliance with the order of the Act.
This letter was issued
411.
my lord, in compliance of the my lord, contempt case, my lord,
Yes.
that passed by the civil division. Thereafter, state has filed a review. That was disposed in the year 2013.
What has been said?
In that case, my lord, this honorable court has directed only to pass
Salary
the-
part removed.
no, salary part remove and complete the proceeding within 6 months in the title.
Thereafter, title suit was had gone against
Gone
him.
again.
But the title suit, title appeal, both, my lord. In 2018, it completed. And by the time it completed, my lord, the school got amended. But the direction of the government to withdraw the department proceeding, whether under any count, my lord, never revisited.
In the year 2011, petitioner
Because, my
has
lord,
filed an
If
petition.
I went to the tribunal, my lord, the tribunal was not for any ouster or something. It was for salaries. Now, there has to be an ouster. And that was done by that order which has been subsequently withdrawn. Let them pass fresh orders, my lord. In the meantime, my lord, I should be given what is due to me, my lord, in terms of their own decision. The DI cannot be over the, my lord, the authorities.
Very appointment of the
Fine.
petitioner is illegal. My lord.
Fine.
How can the authority pass an order, my lord? On a
My
illegal
lord, that
appointment?
is the exact reason why, my lord, I am only saying I am only with the last 3 annexures, page 116, the charge sheet. Focus.
In the
Same
year,
But
charge.
Mr.
my lord,
Vora, your instructions are not adequate and complete. On the one hand, you have the director's letter. He is writing to the government that DI is not paying because DI thinks that there is illegality in the appointment. But the director says that you go ahead with the payment of salary. Now who's to take a call? The director or the DI or the department?
now department has to take a call.
You are representing the department. None else. You have obtained complete instructions.
My lord.
This appears to be inadequate. Neither here nor there. In fact, this matter can be resolved without an intervention by the court. It's your decision. You abide by it.
Thereafter, we leave it. We give you liberty. Because Purkasta, personally, I don't think he'll have any issue. His services are not being affected. He only says that the petitioner was inducted illegally. That is a different matter. The government to decide. But so far as his status as headmaster is concerned, that's not going to affect you.
But here, even they can do one
Actually,
thing.
you can Ireland in a council for the. Why did you copy them? এখন দেখা এখন পেজ আছে এখন আছে
Three copies, sir.
এখন এখন পেজ আছে এখন কোড আছে পেজ থ্রি পেজ না ঠিক লাস্টের ফোন 11:30 Pursuant to the order dated 12/6/2023, the P.K. Bora understanding heard the UK and Ireland Standing Council for the petitioner. Also heard the P.K. Bora understanding council elementary education, whereas the B. Purkast Learned Council has appeared for response number 8. Para. Pursuant to the order dated 12/6/2023, Sri Bora, the Learned Standing Council, has placed before this court written instructions dated 17/6/2023, along with which two communications dated 14 October 2011 and 4/11/2011 have been enclosed by the communication dated 4/11/2011 issued by the director, the department has been requested to issue necessary instructions to the DI of schools filter to release the monthly salary to the petitioner. They said letter further records that the DI of schools was not willing to release this salary to the petitioner, as a letter seeking clarification has been written by him earlier regarding the illegal appointment of the petitioner. It appears that there are difference of opinions in the instructions obtained and the internal communication. Since the ultimate decision has to be taken by the department, the Bora Learned Standing Council is granted further time of 2 weeks to obtain the instructions. This court is also of the view that if the grievances of the petitioner of the view that the present dispute may also be resolved at the level of the department, in which case this court may explore the option of giving liberty to take further action in accordance with law. We have given you enough, and now
Obliged.
nine.
May I please, here, because of.
Division bench.
Hello?
Division bench. Division bench judgment against you. DB judgments against you.
No, that doesn't cover my life. This is regarding language tutor, there is different. I have gone to How it is?
He was not provincialized at a particular point of time when the act existed. Consideration under that
No,
act.
in
The
our
judgment dated 13/11/2019.
Yes.
Passed in WBC WA 283.
yes, I got the copy. Here our case is different, my lord. Our schools have been provincialized. Now we do not come under the school provincial act. 2017 act is out, and 2011 act is out. So we are in a meeting position. We are not provincialized because since we are appointed since 1992 onwards.
What about the present act?
My lord,
Present act. 11 is gone.
2017 also not applicable for us
Why?
because school is provincialized. That act is, my lord, very preamble of the act to provincialize the teachers of the fancy school. Now our school no more fancy. There is a complication here. But otherwise we are entitled because only 2 petitioners may not be entitled, my lord, who were upon 8, 9 and 2010. Other up to 2005, because Contempt is 2006, were entitled to be provincialized. Only ground was that we were excess in terms of the section 4 and schedule of the act.
Mr. Muzumdar, what do you say?
My lord, if that argument is to be accepted, then under 2011 for the or judgment of the Honorable Court, my lord, no consideration for provincialization. And if the submission is that under 2017 act, he cannot be provincialized, he has lost out on provincialization. Nothing more to me. So if the division bench judgment is followed, at least the consideration under the 17 act, because others have approached and their condition as of today has been taken into account and their cases are under consideration. If the stand is that under 2007 it cannot be done, if it comes from the petitioner. Under 11 it
How
cannot
many
be done.
petitioners are there?
I think it's
48.
48. Because my lord, 2017 act says, it named the act itself is, my lord, Assam Educational Provincialization of Service of Teachers and Reorganization of Central
of education.
of Institution Act 2017. So this was for venture to provide provincializing service of the teachers of the venture education institution, also to reorganize and streamline the educational institution up to degree level in the state of Assam. So our case, my lord, 2017 Act is formalized. And teachers therein who were formalized, they were formalized. We were left out. Then we'll have to go back to the date when the school was formalized. Then only our case will be considered from that date. That is our case. Suppose the school, they were formalized in, but here the school was by 2011 Act, 1/1/2013, because this Act was shut down in 2016, 23/9/2016. Thereafter, there was a review, my lord. In review, there was some protection given to the already action taken. But on 1/1/2013, we were not formalized.
You want the effect of provincialization to relate back to the date of provincialization. That is your case.
Now, if otherwise, if our because school was not provincialized, it was bench school on 1/1/2013. So it will relate back to that.
That is what the division bench judgment.
What has the division bench said?
Division bench judgment that is-
Is it page 56? Chandan Kumar Neu.
No, the
What is the name of the party?
the judgment in WA 280 of 19 that order dated 13/11/2019 number. That itself says that cannot be provincialized.
3011.
13/11/2019.
Have you annexed somewhere?
The judgment that was September.
I know, but have you an annex somewhere?
No, madam, that is not.
Where do you get a judgment copy?
In 4 or 5 cases, single bench have passed the judgment, my lord, that those who are qualified on age and 1 or 2 13, they should get to benefit of that.
Hmm.
And on that basis, my lord, in my case itself, 51 teachers have already been taken into consideration under that act of old act, which was repealed. Because a lot, his lordship, protesting, then also Kintamala Bazar Burwa, then one got 3 benches have passed the same order on that basis. PTD also has done that. So, my lord, can it be taken after tomorrow if possible, then we'll sorrow.
But have you gone through this division bench?
I have not gone, just I have had a glance, my lord.
This is another judgment of another division bench.
And senior counsel is referring to 3 other single bench.
Well, although there were some judgments which were given the benefit of a deemed provincialization sort of a thing. Well, that has been deferred to my lord, and there is another judgment of this honorable court, my lord, where difference has been brought in and such claim for deemed provincialization has been dismissed. That judgment I am not saying at this moment. my lord.
You then get copies of the judgment. Let us be aware of what is the.
And the other division bench judgment which I have just given, my lord, paragraph 16, division bench is very clear. There can be no direction or mandamus under the 2011 Act.
Let Mr. Sharma be.
All the copies.
But
I'll give him copies.
we cannot be without remedy, man. There will be some remedy somewhere.
No, there is one more
Either
aspect.
you say that we will promote on 2017.
No, there is one more aspect.
Remedy is to challenge the judgment in the Supreme Court.
There is only one judgment, one order.
No, my lord, first let us start to it.
There is one judicial order, my lord, where all provincialization matters are now to be taken up by a special division bench, my lord, constituted by the Honorable Chief Justice Assembly.
Is it?
Yes, my lord. There is another order on that.
On the administrative side?
My lord, no, in a judicial order, it has been given that it will be taken up by division bench. All provincialization matters relating to any sort of provincialization will now be placed before a special bench. So registry has to place before the special bench.
When was the order passed?
For the first 2 minutes, my lord, I just
Can we record it?
send a copy of it. Yes, the order is there, my lord. Just mail it.
Then we'll not say anything else. Let
Let it be.
Heard free RP Sharma Learned Senior Counsel for the petition. Full stop. Free R. Mazumdar, Learned Counsel for the Secondary Education Department. However, submit that recently there is an order by the division bench. By the division bench directing that cases relating to provincialization of services be listed before a special division bench, correct?
Yes. Order to mail to you. WP1. Read 184 of 2023.
Which was passed in WA 184 of 2023.
Order dated 2
By order dated 2/6/2023. Registry to verify and proceed in accordance with law. You can take this back. It may be.
Alright.
Matters of provincialism means
All matters which claim provincialization in any manner or are challenging the Act of 2017, they all will be taken up by the special bench.
are you sure?
Yes, madam, that is what the order says.
If only the act or rules are challenged, then only why provincialism matter?
Because these matters, madam, this particular matter was also before the division bench. Then a portion of it, the challenge to the rule was taken away, and now the matter is before the single bench. This sort of
Don't worry, by that
all matters
order,
are now.
by this 2/6, don't.
Then bench 2 matters. I think 40% are matters pertaining to provincialization.
Yes, madam.
Why should we burden a division bench? What is the purpose of having a bench 2?
That's fallen from
Alright,
the-
that will supersede the Mala
What
government.
one single judge can do, why should 2 judges be burdened? And that way you are curtailing the one avenue
one avenue.
for a writ appeal. And this is not a rule challenging. Has it been a challenge of rules?
Therefore, like this, but this order of 2/6/23 was passed in a writ appeal. Not in a.
That writ appeal is pending.
That is, That is also
I
going-
think the intention might have been to decide it together along with the rate appeal. Might be, we would not know.
taking on all
Okay.
the provincialization matters together.
That will supersede Maharaj government also notification of creation of administrative tribunal for provincialization teachers. That will be redundant now.
That's right.
Obliged.
Okay. Mr. Mazumdar, are your colleagues aware of this?
Yes, almost.
No,
all.
Katoniar of course is there, Mr. Bora, whoever is appearing.
Special provincialization, special bench, it will go.
Because we are having a number of matters touching the aspect of provincialization. This morning also we had done. No, wait.
Special bench will go to provincialization like that.
No, first time we are being aware of this.
So only single bench will be released.
Can you take a copy of this? We can hand over to our court.
Maharaj, I have just writ appeal number 184 of 2023, order dated 26/2020.
Just wait for a while.
The last few days, Maharaj, the registry and we have been constantly in touch.
But while the division bench will take years to finalize. There are so many cases.
There will be some purpose, but I do not know why special bench is constituted. There would be some purpose.
Civil bench two perhaps to then only remain restricted to those who are in service and in service things will settle down.
But how many cases are there regarding the service condition of teachers, disciplinary proceeding? Very rare. There are few cases of transfers.
From 2012,
Mainly are
2012 to 2017, mostly provincialization matters. 13 the act was enforced. From then on, everything was
Panok Chandra Deka.
earlier.
All the matters, including the single bench, will repetition. Division bench, repetition. And read appeals within 3 weeks. Even a read appeals will go on to their bench.
Writ appeal doesn't matter. Writ appeal is for DB, but single bench.
In fact, Maharaj, the solution, best solution would be if the government also had amended the Assam Administrative Tribunal Act and made a provision for Maharaj, that even provincialization of issue will be taken up by that. That will solve. But
Yes.
now,
There is the educational tribunal which
no, there will be district-wide. District-wide, then there will be multiple of then they are already burdened. Districts are already district.
educational tribunal is framed by another team.
Yes, next.
TMF adjustment, from the educational tribunal in that we have. Obliged.
Obliged.
May I please? Still senior counsel, you can come until he comes. Lordship may allow me to start.
What is this matter?
That pertains to appointment of teachers in lower primary and upper primary school.
Hmm.
And the issue here is that basically that whether the 2 years diploma elementary course, diploma in elementary education, the candidates having diploma in elementary education of 18 months course is eligible for fresh appointment or not. Basically, the petitioners are the candidates who are the having 2 years diploma course along with the other requisite qualification, and the respondents have appointed the teachers candidates who are also having 18 months of DLS course. My lord will get the advertisement first. My lord will have a look at the advertisement. Search from page 51, and the relevant qualification is at page 53.
Yes.
You have 2 years diploma in elementary education.
Yes, my lord.
And candidates have been selected who have 18 months.
Yes, my lord.
You say that that is not adequate as per
Yes.
ANCT rule.
Yes.
Yes, yes.
My lord,
Not only as per the NCT rules, as per the advertisement also, my lord. As per the advertisement, the prescribed qualification is 2 years diploma course. My lord.
How could you relax?
my lord, we have not relaxed. 18 years diploma course was introduced only for those in service teachers who could not get the DLED qualification because of their service condition. Now the NCT has recognized them to be equivalent to the DLED, the 2 years DLED course. Because for undergoing the 18 months course, 6 months is a training period which the regular students have to undergo. Since these are already
In service.
therefore that 6-month period was done away with, 18 months was given to them, and there are judgments of honorable high courts which have given equivalence, which have struck down the provisions where these 18-month DLS students.
Are you restricting this 18 months only to in service candidates
Yes.
and not to fresh candidates?
No, sir. No, sir.
My lord, they have appointed as a press candidate, my lord, for the persons having the 18-month DLS course.
Yes.
My lord, my lord, may have a look at the page 53.
See, your issue will not be tested from the how they are appointed, in which capacity they are appointed. We will see how they are appointed. Who are these candidates?
My
Did
lord,
they have the experience of being in-house candidates, or are they fresh candidates from the market?
no, my lord, why recognition has been given? My lord, kindly have a look at the recognition order first. Page 105, my lord. Why it was recognized, my lord? The 18 months course. Where is my lord, got it?
Yes.
Where is the matter of recognition of the project proposal of National Institute of Open Schooling News, Noida for DLED OTL program through SHAM portal of MHRD for training in service untrained teachers was considered by NRC and NRC observed as follows. And whereas the NCT has received directions under section 29 of the NCT Act 1993 from the Ministry of Human Resource Development, right? Their letters number so and so. The project proposal for recognition of diploma in elementary education DLS program through OTL mode has been submitted by National Institute of Open Schooling News of NCT. The proposal is for conducting online DLS program through the SHAM portal of the Ministry of HRD for in-service untrained teachers at elementary level. It was only for in-service untrained teachers. And the background of this recognition, my lord, why it was recognized, my lord? I'm submitting, my lord. Because more than 14 lakhs in-service candidates who were not having the eligible criteria as per the NCT rules when the RT Act was amended, my lord, in the year 2017. If my lord have a look at the RT Amendment Act,
Yes.
well, this act may be called the Right of Children to Free and Compulsory Education Amendment Act 2017. It shall be deemed to have come into force on 1st day of April 2015. In the Right of Children to Free and Compulsory Education Act 2009, in section 23, in subsection 2, after the provision, the following provision shall be inserted, namely, provided further that every teacher appointed or in position as on the 31st March 2015 who does not possess minimum qualification as laid down under the subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the Right of Children and Free Compulsory Education Amendment Act 2017. Means the persons who are not having the requisite qualification as per the NCT before 31st March 2019, therefore they will have to lose their jobs. For saving the job, this recognition order was passed, my lord, not for the fresh candidates to be appointed. And my lord, in the MHRD, and the NCT has also clarified in their affidavit in opposition that it was not for fresh appointment. if your lordship have a look, first, the prescribed limitation of the entity.
Then how do you apply these guidelines?
My lord,
How do you apply this?
this minimum qualification.
Yes, is the amended portion. How do you make it applicable? If it doesn't apply to in-house candidates?
So only to save their jobs, my lord. Only the who are already in service candidates, to save their jobs, the government has recognized it, the NCT has recognized this for 18 months, but not for the fresh candidates, not for the fresh appointments, my lord. Our submission is, my humble submission before your lordship is that it can be used as the to save their jobs.
There are private respondents here.
No, my lord. As the whole procedure is malpractices, with malpractices, therefore we did.
They will not be affected.
My lord, maybe.
Maybe.
My lord.
Maybe.
My lord.
Their jobs will be gone. They may be affected.
My lord, the honorable division bench order is also there. If the whole procedure is done with malpractices, then the affected party may not be a necessary party, my lord.
Let us see. Under what circumstances?
No,
What is a malpractice?
my lord, if your lordship kindly have a look from para 16, my lord.
Of the divi judgment?
Yes, yes. In P. Prabhakar Rao Supra, the contextual facts disclose successive variation in the age of superannuation of the employees of the government of Andhra Pradesh and the challenge to the consequential ordinance regulating the recruitment and conditions of service effected thereby, responding to the plea of non-joinder of necessary parties. In the negative, their lordships ruled that relief claimed was of a general nature and against the state, and no particular relief was claimed against any individual. It was held that the failure to implicate all affected parties was not a bar to the maintainability of the proceedings in the special circumstances of the case. Next para, my lord. The same view in essence was expressed by division bench of this court in Dilip Kumar Datta Supra. The lordship enunciated that in the writ petition under Article 226 of the Constitution of India, necessary parties are those without whom no order can be effectively made. They are against whom relief is sought, and that in whose absence no effective order can be rendered by court. While marking a distinction from necessary parties, the lordship ruled that a proper party is one in whose absence an effective order can be made, but whose presence is necessary for a complete and final decision on the question involved in the proceedings. The aspect of natural justice vis-a-vis persons not implemented, yet likely to be affected in the event of interference with a process in which they had advantageously participated was dwelt upon by the apex court in Vishwaranjan Sahu and others versus Sushant Kumar Tinda and others. It was observed by their lordship that in a selection process marred by malpractices, issuance of notice to the selected persons would not be fruitful. And the next para also very important, my lord. The plea of estoppel by conduct of acquisition against the candidates to repulse the assignment of examination in which they had participated also did not meet the approval of the apex court in Rajkumar versus Saktira Supra. The lordship ruled that if the entire process is obviously illegal, thus an assertion has no application.
See the factual.
My lord, basically,
more
than that, my lord.
The pleadings which were exchanged.
Yes,
Don't jump to the conclusion. Answer the question of the court. Come to the facts of this case. Facts of the case at paragraph 3.
Yes, my lord.
What are the malpractice? Large scale copying,
yes,
which were admitted. Here you are in an interpretation of a statute. According to you, this is not for in-house candidate, it is only for direct recruits.
My lord, this is not an my humble submission, my lord. This is not an interpretation.
This is your opinion. Are you saying that there is malpractice?
My lord, basically why I'm saying that it is malpractice, because in the advertisement, they have prescribed it 2 years. They never mention in the advertisement, so whatever NCT may be said, but in the advertisement, they have mentioned as 2 years, means it's 2 years. They cannot relax it, my lord. And there
us
is no
see the
mention that they can relax.
Let us see the advertisement.
My lord.
Page.
My lord, it starts from page 51, my lord.
5.1.
5.1. And the relevant portion, the minimum qualification is at page 53, my lord. Essential qualifications and experiences, senior secondary or its equivalent with at least 50% mark and 2-year diploma in elementary education by whatever name known. It is 2-year name, 2-year diploma in elementary education. And they never mention that they have the power to relax and such things. Whether they can relax.
What is 8? What is 8, Mr. Mazumdar? 8. Page 53, 8. The regular teachers. 8.
Regular teachers working in LP school are not allowed to apply in any post in LP schools, and regular teachers working in UP schools are not allowed to apply in any post in UP.
However,
regular LP teachers, if otherwise eligible, may apply in UP schools through proper channel only. Lower
that means working regular LP teachers can apply for UP school.
Yes.
And 9.
All eligible contractual teachers may apply to any one of the posts. Contractual teachers are those who were engaged under the SSM, the Service Shiksha Abhiyan scheme. Those
So you
teachers may
are
apply
saying about in-house candidates. Which are the in-house candidates?
those LP teachers, those LP teachers
Who wants to be UP teachers?
who wants to be UP teachers, those are in-house, and those contractual teachers
These
who
are
taken
in-house.
in without the
That means 7 and 8 are the in-house candidates.
8 and 9.
8 and 9, sorry,
8 and 9 are in-house candidates.
And
Also,
then-
those teachers who were in some private schools and have obtained that 18-month degree and diploma, they would also be the in-service teacher.
And pass the teachers. Where is that requirement of 2 years?
The tabular form lordship will find
below that.
the table.
Candidates who have passed that for 6, they are not eligible.
Therefore, table matter. Minimum qualification, third column. Senior secondary or its equivalent with at least 50% marks and 2-year diploma in elementary education by whatever name known. Or senior secondary with at least 45% marks and 2-year diploma in elementary education by whatever name known in accordance with NCT Regulation 2002. Senior secondary with at least 50% marks and 4-year ELL. Or senior secondary with 50% marks and 2-year diploma in education and passing TET and passing.
You have 2 years diploma.
Yes, my lord.
Where is the ultimate select list?
My lord, the provisional select list is that from page 86, my lord, Annex 7.
Page 86. When were the appointments made?
The final result, my lord, on 28/8/2020.
2020.
28. My lord, the stand of the NCT in their affidavit, if my lord have a look at the affidavit of the NCT,
Page.
my lord, running page, my lord, in their affidavit at page 2, my lord, respondent number 3, my lord. Affidavit filed by the respondent number 3.
3.
At page 2, my lord, para 3.
Just a minute, just a minute. Who is the deponent?
The deponent is Dr. Vijay Kumar. Vijay Kumar R. Oh, yeah.
Reply. Reply to can you Response number?
3, my lord.
Yes, yes, what I think. Vijay Chaudhary.
Yes. No, my
No,
lord.
this is 2.
Dr. Vijay Kumar R. Vijay Chaudhary is respondent number 2, I think.
171.
Yes, 2.
Yes, yes, Dr. Vijay Kumar R.
Yes, my lord. Page 2, internal page 2, para 3, my lord.
Just a minute. Yes.
The answering deponent begs to submit that the NCT recognized the 18 months DLS program only as one-time measure, and the same is not for regular appointment. As teacher in LP and UP school, as such, selection of the candidate having 18 months DLS degree for fresh appointment in any LP school or UP school are not at all acceptable and valid one. This is very clear stand of the NCT, my lord. And even the respondent number 4 also, the Ministry of Human Resource Department, they have also stated from their annexure, it's applicable clear, my lord, that it was only to save the jobs of the in-service candidates, my lord.
You're referring to?
My lord,
You're
the
referring to?
affidavit filed by respondent number 4, my lord.
Yes, which part?
My lord, at page 6, my lord, annexure A.
Page 6. Yes.
Before the recognition, my lord, this is regarding training of untrained in-service elementary teachers in gov-aided unaided private school. It is apprised that the amendment to section 23(2) of the RT Act to extend the period for such training to 31st March 2019 has been passed by the Parliament. Further, it is reiterated that this will be the last chance to acquire requisite minimum professional qualification, my lord. Further, it is reiterated that this will be the last chance, my lord, to acquire requisite minimum professional qualification. Any teacher in the aforementioned schools who does not have the minimum qualifications mandated under RT Act 2009 would not be allowed to continue in service beyond 1st April 2019, and procedure for dismissal shall be initiated against such teachers. Why it was that, my lord? To this recognition, a broad strategy to complete the training of all such in-service untrained teachers by 31st March 2019 is proposed by MHRD. The following action is required to be initiated urgently at your end. And my lord, at page 8, the last paragraph, paragraph 13, my lord, if your lordship have a look at this para Roman 13 of page 8 of respondent number 4 affidavit. The unqualified in-service teacher in gov-aided private schools who fail to enroll on or before 15 September 2017 are liable to face removal dismissal procedure against them.
Fail to enroll before 15th of September.
Yes. That's why the person who were already in service but does not have the requisite minimum qualification, they were allowed to join the 18 months DLS course to save their jobs, my lord, not for the fresh appointment. Even in the advertisement, they have not mentioned anywhere that they have reduced the course for
How
6 months.
How do you manage the situation, Mr. Mazumdar?
My lord,
They let them complete 18 years, then they would be regularized. How can you adjust them against press vacancies?
my lord, we are not adjusting them against place vacancies. We are considering
The
them
moment
for
you fill up a vacancy
Yes.
by any of one of those teachers,
Okay.
it amounts to curtailing somebody's due, maybe
This-
consideration.
These were the very issues which were before other Honorable High Court. I'm just trying to cut it short. And the Honorable High Court said discussed in length what would be the rights of these 18-month DLA course persons vis-a-vis fresh appointment in government institution.
Okay.
It has been upheld that they will be at par with those who had done the 2-year course. This 18-month course will be, the 18-month DLA will be at par. Not only that, the NCT, which filed an affidavit here, has agreed to those judgments and have adopted those judgments and have declared them to be equal. So at this present, Malal, it is there with my affidavit in opposition.
Age affected by whom?
Affidavit by my lord, Mr. P. Judum. Sorry, Vijay Chaudhary, my lord. By respondent number 2.
R2.
R2, my lord. There, if lordship has page, running page 11. Is one of the judgments. This was by the Patna High Court.
Yes, we have found.
At page 23, my lord, of the affidavit. Paragraph.
No,
14.
no. Who's the reply affidavit? 1117.
Was filed 12/8/2020.
In 158 করবে আহিলে
running page.
একটু হল দেখো 16 দেখো 15 158 করবে আহিল খুলিছিল এটার উপরে যাব না এখানে ফুল এলাই হইছিল থেকে মই যে ভিতর এখানে উপরে যাব প্রথমে যাব Yes, found it. Where is it?
My lord, if lordship is running page 23. It's the judgment of the Patna High Court starts, my lord, at page 11.
Yes. Why Vigiri?
Why we agree, my lord, yes. And if lordship has page 23, my lord. I'm just cutting short the other discussions, my lord.
23.
Page 23.
Internal 23. Internal page 23.
Of the judgment of the affidavit. That's the para 14.
14 years.
From where perusal of all the NCT formalities while going for this 18-month DLED course has been discussed prior to. Now, in para 14, they say, from bare perusal of the decisions, it is apparent that the NCT recognized one time the course in DLED conducted by NIOS. The relaxation of some period was only granted to the in-service teachers who had not obtained the required degree training course, such as B.Ed or DLED, which is made minimum requisite qualification for appointment on the post of teachers in elementary and primary school. Thus, it cannot be said that the teachers who had obtained DLED through NIS or any other institute duly recognized by the NCT is not at par with the 2 years period DLED course as prescribed under section 23(2) of the NCT Act and Rule 5 of the Bihar So-and-so Teacher Rules. From the perusal of the letter as contained in Annexure 10 issued by the Under Secretary Regulation NCT, it appears that the NCT has simply informed the Additional Chief Secretary by way of clarification that as per NRC NCT order dated 22/9/17, the DLED program of NIOS is only for those untrained in-service teacher in government-aided or private unaided schools appointed on or before 10/8/17. But it is nowhere mentioned that the said course cannot be treated at par with 2 years training course, and on the basis of such directions, 2 years degree course, whereas the same course was duly recognized by NCT pursuant of the directions issued by the Government of India MHRD under section 29 of the NCT Act. Thus, I find that on misrepresentation and misreading of the clarification issued by the NCT, the Director Primary Education has illegally issued directions that the persons who obtain DLED course duly run for 18 months by NIOS are not eligible for appointment on the post of teachers in primary schools, and thus the letter as contained in Annexure 11 is illegal, unsustainable, and violative of Article 14 of the Constitution. Writ petitions are allowed. Respondents are directed to allow the petitions to apply within 1 month and consider the case of petitioner for appointment to the post of primary teacher. Second judgment, my lord, came at the next page in the Honorable High Court of Tripura at Agartala. This was on 12/3/2020. Again, after a lengthy discussion, my lord, lordship will find at page 40. This was again by those, I'm sorry, my lord, page 39, my lord, para 17, if lordship has. Page 39, para 17. There the state government had opposed. State government has said we will not allow the 18 months DLED persons to participate. Page 39, para 17.
the other side were before the court.
My lord, yes. The ones who had 18 months DL course were before the court. If we accept the opposition of the state government to the validity of the qualifications acquired by the petitioners on the ground that the program duration was 18 months against that envisaged of a full term of 24 months, the entire purpose of NCTE in recognizing such a course as one-time extraordinary measure, looking at the unusual emergent situation, would frustrate. In plain terms, the state government had no authority to overrule discard the decision of the NCT in the field. In any case, the state government policy cannot be at loggerheads with that of the union government and its statutorily constituted body.
But NCT in this case has said something else.
Lordship will kindly have page 42. The stand of the NCT.
No. In
The
our
affidavit
case.
is- in our case only. Affidavit of the affidavit filed by the regional director is one part. The stand of the NCT as given publicly at page 42. Lordship will find.
R.K. Mahajan.
R.K. Mahajan, Additional Chief Secretary, so please refer to this is to R.K. Mahajan by Vijay Kumar R. Lordship finds.
Yes. He is the one who had filed the.
Same person. Now Lordship will find on 19/5/2020. He says, please refer to your letter number so and so on the above mentioned subject. It is brought to your notice that the NCT has decided to accept the verdict of the Honorable Patna High Court in the case of Sanjay Kumar Yadav. Jurisdictional so and so. The decision is taken pursuant to appropriate direction from the Ministry of MHRD to take over for further necessary action in the matter. This affidavit, my lord, of R.K. Mahajan was filed. Vijay Kumar R was filed before this honorable court
On 16th October
16 October
2020.
Down below the signature is 28/9/2020.
Yes.
And on 19/5/2020,
Prior to that.
prior to that, they had already.
Who is appearing for NCT? Who is appearing? Whose name? Borbuya or Mr. Alam?
Borbuya.
What is his name?
Ramesh Borbuya is there, I think.
Where is he?
Personal difficulty is not present.
We'll have him in his presence.
My
I
lord,
cannot
he
take
has
two
to explain
stands.
this.
My lord, anyway, suppose whatever my senior counsel has been arguing may be right, but they have not anyway mentioned that they have the power to reduce the diploma course to 18 months, my lord. And they are not allowing any person of 18 months course. Their main prescription is that, my lord, 2-year diploma in elementary education, my lord. Whether they can go further.
No, that is the secondary aspect. First, this diploma, the
My lord,
requirement has come from the NCT.
My lord, my humble submission is that this is the primary aspect, my lord, here.
No, from where do you get the diploma of 2 years? When does it arise? From the NCT?
Yes, definitely.
Let them clarify.
My lord.
If they say that, no, this is the meaning. Now, in this case, their stand appears to be something else. And in the latter, their case, they could have very well challenged the order of this Patna High Court.
But no, they did not.
They haven't.
MHRD, then in fact, the respondent number 4's affidavit says this 18 month is subsumed. The matter was the stand of the Ministry of HRD. Human Resource Development.
Yes, what is it, Mr. Chaudhary?
I may take the lordship to.
What role do you have? What is the role of the ministry?
Lordship, I was impeached subsequently on the basis of a communication that has been attached to them.
No, what role are you playing here?
NCT is doing the.
NCT.
It's another ministry, that is why. And
But NCT is into the autonomous body.
Yes,
it's not.
it's a statutory body.
I think
As per the Right to Education Act, the Ministry of Human Resource Development was to give the burden of lower primary education to any organization it deemed to be.
My
That
lord,
was given to the NCT. And therefore, my lord, the Ministry of Human Resource Development had clarified to the NCT that with these judgments, the 2 years and the 18 months will be equal. That is how the NCT comes to agree with the
my
judgment.
lord,
They have sent it, and the Ministry of Human Resources.
Mr. Chaudhary,
my
what do
lord,
you say?
NCT has been established under the NCT Act, my lord. It's a statutory body. They have the right, my lord.
What do you say?
Lordship, if I may take a lordship to my
You file a very well. Through
it is
Avinash Chandra.
Already
Avinash Chandra.
I read that.
Lordship.
Yes.
The relevant portion, Lordship, will find at here.
Page,
Paragraph 7, page 3.
para 7.
Yes, Lordship. So far as this 18 month and 2 years thing is concerned, Lordship, and I've extracted it in paragraph 7. Lordship will see page 3 below.
Yes.
Subpara 2.
Yes.
Any provision related to the duration of the program so as to reduce it to 18 months instead of 2 years and the requirement of 6 months internship to be subsumed within the duration of 18 months.
Where are you reading?
If your lordship,
Page 3,
page 3, paragraph 7.
paragraph 7. It starts with reference to statements made in 10 and 11.
Yes, yes. Lordship will come below.
Yes. In this regard.
In this regard, and the last lordship, Roman 2.
Roman 2.
And page
Any
3,
provision.
page 3 below. Page 3 below.
Page 3. Yes.
The italicized lordship.
That is in page 4.
No, it starts at page 3.
No, the 1 and 2, 1, 2, 3 is in page 4. Paragraph 7 no doubt starts at page 3.
Yes.
There are two main paragraphs, one subparagraph, then in italics it starts at page 4, 1, 2, 3.
Oh, lordship, some
Doesn't matter which one.
lordship 2.
Roman 2.
Roman 2.
Any provision.
Any provision.
Yes, please read.
Any provision related to the duration of the program was to reduce it to 18 months instead of 2 years and the requirement of 6 months internship to be subsumed within the duration of 18 months. Therefore, lordship, the period of 2 years, lordship, it can be read as 18 months. It's subsumed within that period.
Otherwise, in 2 years, normally,
Yes,
does it include 6 years of training?
6 months.
6, I mean,
Yes.
6 months.
Yes.
So, even if we accept your submission, then the point would remain that whether the terms in the advertisement could have been relaxed, number one.
That lordship,
Number two,
that lordship, I have stated in the opening paragraph of the reply to paragraph number 10 and 11. Lordship will kindly see that has been left to the state government.
Yes.
May I read it, lordship? With reference to the statements made in paragraph numbers 10 and 11, the deponent begs to state that the prescription of minimum qualification by the NCP
advisory.
is advisory in nature. Education being a subject in the concurring list and as per Schedule 7 of the Constitution, the state government is competent to decide as per the state's.
Then the second point would be whether in a direct recruitment, the in-house candidate could have been.
That lordship, by the state.
But I think that advertisement contains from LP to UP it's allowed and
Yes.
contractual.
LPT, because from the same, when one person is working in the government, the logic was when one person is working in the government at the school, he should not apply to a school just to come to a school in Jorhat.
In the same status cannot.
In the same status, he should not be allowed to come. But if he wants to come from an LP to an UP school, then he should be allowed. And contractual teachers, if they want to become regular employees, there should be no bar. That was the reason, my lord, why that regulation was there.
And the persons who had got the benefit, of course, they are not before us. We do not
They
know.
are not.
Are there any persons who had applied from LP to LP? That cannot be perhaps.
LP to
LP, no.
from LP to UP.
LP to LP, you cannot, there's a bar. I think.
There's a bar.
Okay, we'll have this day after tomorrow. Barboya's name has been recorded or not?
Yes, his file is.
Where is he? His colleague? Day after tomorrow, ask him to be here.
He's praying for after vacation.
No. 2020 matter. He's not around or what? We'll have a day after tomorrow. During the time of consideration of this case, it has come to notice that the stand of the NCTE, which should be of crucial importance, is different in the affidavit filed in these proceedings and certain communications which are issued in respect of similar cases in other high courts. Though the name of the NH Barbhia standing counsel has been reflected in the cause list, he is not present today. Please for consideration on Thursday next. Give the date, please.
High level.
এখানে ঘুরাই দিব এই দুখন এওর আছে আর এখন এখন কি কোনো একটু wait. Yes.
Check my lot of the record executed by the NCT in certain cases. The director had to be personally called to the honorable court because he was filing contradictory activities in same issue on different repeats.
Let us see what he said. What is it? Yes.
Can I take up term number 12, man?
12. Review.
Review, man.
You are seeking review.
My lord.
Mr. Sharma, you are for the writ petitioner.
I am for the writ petition. For real, I am for the writ.
And you are for?
I am for the writ petitioner, Lord. You to contempt on that.
Yes.
I am for the writ petitioner here, the sole respondent.
No, man, respond number
1.
That is, you are the writ petitioner also.
Yes.
You are with him, Mr. Sharma.
For the contempt.
Same thing.
In item 11, Lordship, they have filed.
The contempt.
Yes, Lordship. So he is also a writ petitioner in that case. But contempt, they have preferred Lordship in review application. I am here.
Okay, you are defending the review.
Lord.
Okay.
Just I'll face the facts, my lord.
Let us first read the judgment.
My lord.
And that thing will be clear.
My lord. It is page 13, my lord. Starts from page 16, my lord.
1-6.
1-6. It's a review petition.
1-6.
16.
1-6 is the judgment of a Supreme Court.
No, but perhaps it is a written argument there. Review petition
78
of 16, my lord.
1-6.
1-6.
Okay. Justice, Honorable Justice Vaipai.
My lord.
Yes.
Pardon the line from support of petition. No representation from any of the respondents. So the names of the council are reflected in the cause. In this petition, the petitioner is questioning the legality of the levy of excise duty of so only on his bill for lifting of scrap materials awarded by the respondent number 1, by option dated 9/4/2010. The basic contention of the petitioner is that he is only the buyer of the scrap materials and has no liability of excise duty whatsoever, as the same is to be borne by the manufacturer of the scrap materials. According to the petitioner, in the case of transaction between Free Steel and Indian Oil Corporation Limited, the firm in question was exempted from payment of excise duty. So was the transaction between DD Enterprise and Indian Oil Corporation Limited. For the end of paragraph 6 of the affidavit in opposition filed by the Central Excise Department, Department has admitted that if the capital goods are cleared as waste and scrap, the manufacturer shall have to pay an amount equal to the excise leviable on the transaction therein. Similarly, in paragraph 7 of the affidavit in opposition filed by respondent number 1, respondent number 1 has also admitted that as per Central Excise Law, the excise is leviable on a manufacturer of excisable goods at the rate shown in Central Excise Tariff Act 1985. In the instant case, the manufacturer is the respondent number 1, that is an NIL mallet. In my opinion, on the aforesaid materials, the petitioner cannot be held liable to pay excise duty in the current transaction as well. Resultantly, this petition is allowed consequent to the claim of the excise duty amounting to rupees 7,54,700 made by the Central Excise Department from the petitioner is hereby quashed. It is made clear that if the excise duty leviable has already been realized from the petitioner in the meantime, the respondent number 1 is directed to refund the amount so realized to the petitioner within a period of 1 month from the date of receipt of this order. The petition stands disposed of in the above time. Now, my lord, the question is of levy of excise duty, my lord, on scrap good, my lord. There is a Central Excise rules, my lord, convert to that says, my lord, if the capital good are cleared by a manufacturer by way of scrap or waste, my lord, then my lord, manufacturer has to pay the excise duty. Now, my lord, excise duty being an indirect tax, my lord, it has to be collected from the buyer and it has to be reported in the government exchequer, my lord. That's the NIL has done, my lord. The NIL has collected the excise duty, my lord, and has deposited with the government, my lord. Now, my lord, the direction has been issued in this order, my lord, so NIL to refund it. Now, my lord, the duty has already been deposited with the government, my lord. So NIL is not in a position to refund it, my lord. First thing is that, second, my lord, thing is that, my lord, they are claiming an amount of rupees 7 lakhs, my lord.
Now, where is the error apparent?
I am coming, my lord. It was a contention in the affidavit in opposition, my lord, filed by the NRL, my lord. That excise duty is in indirect tax, my lord, it has to be collected and paid. Accordingly, Numaligarh has collected and paid, my lord. Now, the thing is that, my lord, if Numaligarh has already paid, my lord, how do Numaligarh can refund it, my lord? It is lying with the central government, my lord. The amount of excise duty, it is an indirect tax, it has to be collected, my lord, and it has to be deposited with the government, my lord. If I will refund this excise duty, my lord, then I will be refunding the amount twice. Once I pay to the central government, again I will pay to the as opposite party number 1, my lord. And second thing is that the excise duty which I have levied it is legally levied, my lord. And it was a contention in the affidavit of the my lord that has not been taken into consideration while passing this order, my lord. After filing of the during the pendency of it petition, my lord, the claim is of 7 lakhs and old, my lord. However, my lord, during the pendency of this petition, my lord, excise duty was collected at the rate of rupees 3 lakhs and odd, my lord. Therefore, 7 lakhs they cannot claim, my lord. In that 3 lakhs we have already deposited. They have not denied this fact in this review petition, my lord. And they have also not placed this fact before the court at the time of passing of that order, my lord. It was not subsequent to the filing of it during the pendency.
But where were you?
On that day, my lord, if the notice of the council, my lord, which did not appear, my lord. This fact could not be brought, my lord. So pleadings were there, my lord. And even if the lordship may modify this order, my lord, if the lordship is satisfied that excise duty is to be refunded, my lord, in that case, my lord, it is the central government, my lord, the excise department, GST department. Because we have already deposited, my lord. Lordship may kindly come to.
Tell us your grounds of review.
Page 7.
Page
7, my paragraph 8, 9.
Grounds.
No, it's not exactly in the format, my lord. It's not exactly in the format. There was a mistake in the filing of this.
Where is your certificate?
The affidavit was given. Certificate was not given.
We asked about the certificate, not the affidavit.
My lord.
Where is the certificate?
That is not given.
Then, if you do not certify the ground,
to be ground of review by an advocate. Is it maintainable?
If your lordship go by the affidavit also, your lordship will see how negligently the NRL has prepared this review application. It's not at all maintainable. If your lordship come to page 12, I will show. I, Sri Devasi Chaudhary, son of Sri Soento, has about 55 years.
That he is the applicant.
I am the applicant in the above mentioned review application. Your lordship now kindly come to who is this
Devasis
applicant?
is the applicant.
No,
So who is the applicant? Whether this is maintainable, where is the error apparent on the face of the record, Lord?
my lord, may kindly see order date 3/5/2003, my lord, where court says, my lord, since it's a all pending matter, my lord, instead of going into technicality, it could be hard on merit, my lord.
Where?
Order date, my lord, 3/5/23,
3/5.
23, my lord.
But I am pressing regarding this lordship maintainability of this review application. Maybe it's a long pending case, lordship, but even then, lordship, I am relying on
3/5/2023. In this proceeding,
My lord,
last order is of 17.
there is an order of my lord of 3/5, my lord.
3/5/2023.
My lord, it is in contempt, sorry, my lord,
Contempt.
it is in contempt.
Maintainability ground is open.
Yes, my lord, but court has since this, it is long pending, my lord, instead of technicalities, my lord, it can be decided, my lord.
No.
If
Court has
lordship-
proposes to hear the matter on merit as well as keeping the issue of maintainability open.
Now, my lord, what my prayer is that, my lord, excise duty is already deposited with the government, my lord, and direction is there to
See, what prevented you from filing an appeal?
lordship.
My lord, now lordship will see, my lord, it is their duty also to apprise the court, my lord, during the pendency.
They must have, they might have done anything. What prevented you from filing an appeal? You are an NRL, you are not a layman.
But lordship will
Navaratna,
only
misconduct.
my lord, only one thing, my lord, just lordship will
You don't even know how to file a review. And you are arguing. What are the high court rules? High court rule.
it is not an expert rule, I am admitting it, my lord. It is
Then,
a mistake, my
if you are admitting, where is the provision?
lord. Lordship
Where are the grounds?
for the ends of justice, my lordship
Ends of justice.
is 8% only, my lord.
We go the technicalities for a toss.
No, it's a, my lord, and
Where is the filing required? Throw a piece of paper in the court.
no, my lord.
What ends of justice? There are no grounds, no certificate. And what is the error apparent? Let us assume for the ends of justice.
My lord,
What prevented you from filing an appeal? You had good ground.
my lord, my lord, lordship will see only
Sorry.
one thing. My lord will see only one thing.
Sorry, dismissing this. Third. 3. R.S. Mishra, learned counsel for the applicant who High Court who has
Lordship may grant me liberty to file a fresh, my lord.
now.
Lordship,
What is the limitation?
as per this is 30 days, my lord. But again, I will go to my appeal and all. If lordship allows me to bit of liberty, I will just.
You can prefer an appeal. You can seek a condemnation of delay. Review was pending for such and such days. Depends on the division bench to accept or not to accept. You can put grounds in your memo on your written arguments. You cannot put the grounds in the memo of the review petition.
That time it was a mistake. If the lordship will just give it action to a central government instead of NIL, my lord, then
Under what jurisdiction? Tell us. Where is our power?
Since it's a writ proceeding, my lord, and it may be mistake on my part, I am admitting it, my lord, but if lordship will just raise direction.
This casual attitude will not tolerate. At least this court is very strict on
My lord.
procedures.
My,
We will not tolerate this kind of thing.
that's a simple reaction, my lord. If instead of NIL, it will be
Not
central
in a
government, my lord.
review application. Direction in a review will amount to allowing the review. We are not allowing the review.
Neither petitioner will prejudice, my lord, neither central government will prejudice, my lord. It will be NIL who will prejudice, my lord. He has to pay the amount twice, my lord.
You know your ways and means. You write to the ministry. You are a part of the ministry, aren't you? This affidavit, Devashish Chaudhary, what is his designation?
My lord, he is general manager.
Where
Commercial
have
and
you
legal.
stated?
He is there, my lord.
Still,
And there is defect, I am admitting that.
general manager, if we have to accept it, if general manager were of the applicants, there are 3 applicants. We have just noted senior manager and manager. We're sorry to dismiss this. And contempt. Contempt, what is the position?
And review was pending this order was state, my lord, in review proceeding, my lord.
In review.
I mean, in this review, my lord.
Where is the stay?
So, my lord, 23/11.
23/11. Who will pass orders? Come on, again. Now the order passed. Any matters or interim order still today? Needs to be extended. Any urgent matter, court must